Mr. Chairman, we're live and good to go whenever you're ready.
Thank you, Clarissa. We'll go ahead and resume the meeting. And the next bill that we'd like explained is the state lands grazing of non-owned livestock. Am I correct, Heather? Come on up, Lucas.
Mr. Chairman. Luke Plum, LSO, here to discuss 23 LSO-0204. This is state lands grazing of non-owned livestock. This bill is fairly short and straightforward. The primary change here is within the criteria for leasing. This would simply add a sentence at the end of what is subsection D to basically say that a person who has control of livestock, they do not own them, but they're responsible for their care. They're not required to obtain the approval of the director of the Office of State Lands prior to allowing that livestock to graze on their state land lease. And this bill just has the standard effective date of July 1st, 2023. Stand for any questions.
Okay. Committee questions on this bill? Okay, thank you. Come on up, Director.
Mr. Chairman, I think our biggest concern with 23 LSO 0204 is the impacts to revenue. It's unclear to us from the way this is drafted whether the lessee running non-owned livestock would still be required to pay that half excess rental to the trust beneficiaries. And so with that, as things currently stand with our rules and with the statute, these sorts of arrangements, we consider them to be contracts, any contract that touches and concerns the land. And the rules are such, and the statute too, that if there's any money, if you will, that's made by the lessee beyond what they pay in rental for the use of state lands, they are then obligated to pay half of that rental or the excess rental to the trust beneficiaries. The other piece of this, as you all know, the board and OSLI, we have a fiduciary duty to the trust beneficiaries to manage the trust asset, which is state land. And in order to do that, we need to know and understand what's going on those state parcels. And so we believe that the board has every right and reason to know if people are utilizing state lands for third party or management of third party cattle and anything else that's going on. And that's been sort of the historical piece of this with the legislature and the board to do this and say these are not reportable, they're not approvable, there's no money that needs to be coming in excess rental to the trust beneficiaries. That's sort of contrary to our long-standing practice since at least 1943. I think that's when the legislature first inserted this requirement to pay the half excess rental to the trust beneficiaries. And it was frowned upon to essentially utilize the trust asset for the gain of the lessee, if you will. And so that's really our concern. I was really interested in this topic. So I did do some legal research back in the old statutes, the old rules, just to kind of see how things had progressed over time. And there is a case back even in the late 1950s where a similar situation to this, where I think it's the Rayburn case, where Ms. Rayburn had allowed a third party to graze their cattle on her state lease. And there was some discussion in that case about, is this a sublease? Is it not a sublease? But the court said in that case, it doesn't matter. I mean, it doesn't matter if it's how you characterize it. At the end of the day, the board, in determining what inures to the best interest of the trust beneficiaries needs to have this information and can and should be able to use that information in leasing decisions and even future leasing decisions related to the state parcels. So, Mr. Chairman, that would be our concern really, is just to be able to make sure we're managing and understanding what's going on the land, as well as making sure that the trust beneficiaries are receiving that half excess rental. Deputy, anything else you can think of?
Thank you, Mr. Chairman. Would this be sort of an example if, say, large landowner had some sections, some school sections inside their property and they had it up for lease? This would apply in that situation where he's already leasing out his ground, his grass, and he's got the school sections. He never gave them up. So this would apply to something like that. Is that, do I understand this right?
Mr. Chairman, Representative Fortner, I believe that is the case. That's my understanding too.
Okay.
Mr. Chairman, Director, could you just maybe briefly for the committee's sake, give us an overview of the current process if somebody wants to lease or sublet something that they have leased? So we understand what it is currently now and what these changes might do. That might clarify some of it.
Mr. Chairman, I would defer to Deputy Crowder. He's in the weeds, as it were, a little more than me. He can give you the play-by-play.
Thank you, Mr. Chairman. Representative Clausen, currently, as the statute states, all subleasing needs to be approved by the director. The Board of Land Commissioners took that a step further and said, not only all subleases, but all contracts of any and agreements of any kind need to be approved by the director. So if an individual is not running his own cattle on a state lease, then we understand that to be a sublease or an agreement of any kind. And we require them to be approved by the board. It's been a longstanding practice that the board approves these. It's for whatever reason, and I don't know the history on this, it's gone past the director, but to the board, and it's stayed there. We expect them to provide us with an application or the agreement for the sublease or agreement. We will run that through our processes, and as Representative Fortner mentioned, if there are adjacent private lands or federal lands involved in the agreement as well, we'll separate those out and only look at the state land. So how much of the usage or how much of the rental is tied to just the state lands, if we can figure that out. Once we understand that, we take away from the total amount being paid in that sublease, we take away the state's fee, whatever that is. It's either the minimum or some conflicted amount. And if they're getting paid more than that minimum fee, then as the statute requires, we charge them half of that excess rental. That's the process right now.
Mr. Chairman, I would just add that back in the 40s and 50s, the nature of the statute and the rule just strictly dealt with sublease. It said any sublease agreement needed to be approved by the board. That has evolved over time to the statute we now have, which talks about subleases, but also talks about contracts. And you started seeing the contracts language come in the early 60s. There was a lot, I don't want to say a lot, but there were some cases where the question was, were these sort of third-party arrangements truly subleases because, you know, they weren't surrendering complete control of the state parcel, or were they something different? But my research shows that since the late 50s, it looks like there's been a concerted effort by the legislature as well as the board to include all these other sort of third-party arrangements as reportable to the board. And then if the excess rental piece kicks in, it does. So this would be sort of stepping back from that historic process of inclusion. This would be going the opposite direction.
Representative Heiner.
Thank you, Mr. Chairman. Deputy or Director, we see a lot of these large tracts of land that are leased up for grazing, albeit with federal, state, as well as private lands in that grazing allotment. Sometimes these lessees are subleasing that large tract for hunting. for outfitting of hunters and things like that. Are you seeing any of those contracts coming to the state for approval for a hunting lease versus a grazing lease?
Mr. Chairman, Representative Heiner, I don't believe we do. We do have our own separate process for authorizing outfitting and that sort of thing on state parcels, both exclusive and non-exclusive, but I don't believe that we see the agreements. Maybe you know differently.
Mr. Chairman, no, we don't see those types of agreements come in, as the director mentioned, but I'll also state there's a statute 362-107, I believe, that prohibits that. And in fact, I believe it's a misdemeanor if folks do charge to allow access to state lands.
So if the state land, Deputy Director, if the state land is encompassed in a larger tract and they don't specifically lease out the state land, but that is a part of a larger tract, by that statute you quoted, that is illegal to do that in including, when they include the state lands in that outfitting lease. Is that correct?
Mr. Chairman, Representative, possibly. We rely heavily on the expertise of the game wardens. They would be the ones who would cite for that particular offense and whatever evidence they found for the advertisement or the securing of funds to allow access. They would be able to cite against that. I do know it's a difficult thing to cite against, but the statute's there.
Yep. How about stock growers come up? Come on, Jim. And we'll have other public testimony too. So you were the one that suggested this, and I thought I was more clear on what subleasing was before, but maybe you can explain how you understand it.
Thank you, Mr. Chairman, members of the committee. Certainly, we're not attempting to change the current status with regard to subleasing. If I sublease my ranch or my state land parcel alone, either way to someone else, then that's an agreement that directly affects the state land. And we believe that it should follow the current rule that you get their approval and you share the revenues, et cetera. What we're attempting to address here is where I'm still the responsible party on the state land. I'm the lessee. I'm responsible. I manage the livestock on there. I'm accountable to the Board of Land Commissioners that I don't abuse the land, that I take care of it, everything else. But it just happens that all or a portion of the animals I have out there don't carry my brand on them for a number of reasons. And the examples we've seen recently is with drought, people sell off part of their herd if it's a cow-calf operation. 2 years from now, we have a wet year and there's good forage. That herd doesn't suddenly expand, but they want to take advantage of that. So they agree to bring in some cattle to mingle with theirs from someone else is one case. The other thing is, and again, going back to the previous comments about what it was like in the 1940s and even 1960s, pretty much everyone in Wyoming was a cow-calf operation. Today, we have a lot of people who don't run cow-calf operations. They summer yearlings on their pasture. They may own those yearlings. They may just take them on for the summer. But from our perspective, the key is that they're not turning over responsibility or any authority on that state land to anyone else. They're maintaining their position. They're accountable. And so it just happens that the livestock that they're running out there are don't have their brand on them. They're owned by someone else. But other than that, there's no agreement as to the state land. There's simply an agreement that says, I will run your 200 head of cattle for 3 months out there, and I'll provide all the care for them. I've given some thought to the matter of the excess fee that the state land charges. I tried to find any information I could as to how much revenue that really represents to the state land trust on an annual basis. I've not seen any numbers. Perhaps the director or the deputy could provide that, but I tend to think it's not really significant. But to me, that's comparable to I run my cattle out there and I make $5 a head on them at the end of the year when I sell my calves. Mr. Chairman, you run yours out there and you've got better quality cattle and you make $10. We don't say that because you made a little more, you share that profit with the state land office. And the same thing if and you heard a speaker that was at your last meeting talk about the difficulties he has, and I've heard this tale from many that they get paid so much to run somebody else's cattle out on their place, and say $20-25 an animal unit is kind of the range. Some have been higher than that. Trying to determine, first of all, how much of that is for the forage and how much of it is for the care I provide and the supervision, the responsibility. Then when you break it down and say, oh, if you could break it down, and I think it's rather arbitrary, and say, well, $10 is for the forage, then, well, how much of the forage do they consume on the state land versus what they consumed on my private land? And in many cases on intermingled BLM land, you have that challenge again. How do you break that down? And you could say, well, the state land is 10% of my ranch. Well, but the cattle spend 3 times as much time on the meadowlands, which are the private lands, as they do on the upper land. The complexity of this becomes overwhelming. And I don't think there's any way we can do it that the current system is equitable. It's just arbitrary, and it's someone sitting down and coming up with a number and reporting that. I don't think they're challenged on it, and I don't know how they could totally defend it if you had to really do it through any proper analysis because of the uncertainties that are involved there. So from our perspective, it just makes sense to say that under those circumstances, you don't need prior approval and you don't become liable to share some revenue, some indeterminate amount of revenue with the Office of State Lands. And I don't think that's, in our view, that's not in any way a violation of the trust. The trust says the state gets the maximum revenue they can for that land. It doesn't say that they get all the revenue they can off of my cows or my sheep. And I think that's a little bit different. If you do move forward with this bill, I do have one suggestion for you, Mr. Chairman. The language on line 9C, line 20, page 2, says the lessee is responsible for providing care. I think that's rather broad and nebulous. If I'm just agreeing to put out the salt, am I responsible for providing care, or do I have to have more responsibility? And language that we had suggested earlier to the Office of State Lands was to say that the lessee retains full management authority and responsibility for the livestock. And if they retain full management authority and responsibility, then it's not a sublease. It's not a contract with regard to state lands. If it's anything less than that, then it would be a contract with regard to state lands and justifiably approval from the state land office. But in this case, if it's just different livestock, it's not having any impact on the way the manner the state lands are being managed, the way they're being utilized, anything else. It's just that the lessee happens to have some non-known livestock out there, and they may be indistinguishable except they have a different brand on them. And that seems to us to not be material to the management of the trust land. With that, Mr. Chairman, I'd be happy to take any questions.
Questions, committee? Representative Fortner.
If this has been in place since 1943, why are we now addressing it? Has there been some problems going on, or is there a shortcoming or something that been overlooked on this statute? Why are we addressing it now?
Mr. Chairman, Representative Fortner, as I mentioned earlier, I think that there's been a real evolution in the industry on how we operate in Wyoming in particular since then, that it's not just the typical operation where you own the livestock you run, that people have gone to running yearling cattle that they just bring in for the summer. And just the economics of the industry have meant that you might not be able to afford to own all the animals you need to properly utilize the forage on your ranch. So you bring in some additional animals to get the maximum return you can out of that property. I think that's one part of it. There was a case within the last 2 years that came up where a longtime lessee on state trust land was challenged, and the individual who challenged that did so simply by going to the Wyoming Livestock Board and determining that the brand that was on the cattle he saw out there was not registered to the individual who held the state leases, and just use that as a basis for a challenge. So that kind of brought it more to our attention, but the discussion about this has been going on for probably the last 15 or 20 years, frankly.
Yeah, follow up.
In pretty limited cases, in other words.
Mr. Chairman, Representative, I think it's not very limited today. It's becoming more common every year as people find that just summer operations are more viable than putting up hay and feeding cows all winters there. And then the weather patterns we've had with more variation from drought to heavy weather, I think that's made it just, it's changes in the industry, part of them driven by natural factors, part of them driven by the economics of the livestock industry that have caused it to be more common. And to be very honest, as I've talked with producers around the state and posed this question about running non-owned livestock on their ranch, and they'll say, oh yeah, I bring in livestock, I do this, I do that. And then I'll follow up and say, well, do you have any state trust lands incorporated in your ranch? Oh, sure I do. Are you turning that in? I mean, to be honest, the number of people I've run in who don't even realize just because they didn't have their brand on the livestock that they need to do this is remarkable.
Thank you.
One of the things I'd add to that, so I'm aware of at least one of the problems that Mr. Magagna was referring to. And you talk to their attorney and they insist that subleasing doesn't happen unless the management of the land is turned over to the person that's leasing it. And so there's a question of what defines subleasing, and we're trying to get to that a little bit here, I think, too. So.
And Mr. Chairman, if I may, I think subleasing per se is fairly easily defined because it's a formal document that's a lease. But when the current statute refers to subleasing or any other agreement that affects the land, that's not the exact language, that's pretty close. It's what those other agreements might be that is the issue. And that's where our position is, that agreements just with regards to who owns the livestock that I'm going to run does not directly affect the land, so that it doesn't fall under that. We're thinking it really doesn't fall under that today, and this language in the proposed amendment would help to clarify that and remove any disagreement as to whether or not running other people's livestock was an agreement with regard to the land or not.
Okay, thank you, sir.
Thank you.
Other public comment?
Sometimes I come up here and I said, Brett Moline of Wyoming Farm Bureau. I come up here and sit and I look and everybody's smiling at me. I don't know if that's a good sign or not, but Brett Moline, Wyoming Farm Bureau Federation, sitting in support of this bill. I'll use an example that happens quite a bit that, you know, not that my family has any school sections, but the family ranch has been incorporated. So the ranch owns a lot of the cows, but one of my brothers that runs the ranch, operates the ranch, has his own cows. That's a farm of his wages. Well, if the lease for the school section was under Ex Hart Ranch, but you run Brett Moline and Ex Hart Ranch cows together under, you know, you just run them all together. You don't separate them by brand. This would allow that to happen without any headaches on either side. And there's nothing nefarious going on. It's just the way that ranch is operated, but the lease has to be under somebody's name. And it makes sense to be under the corporation's name that has the majority of the cows. So, Mr. Chairman, sitting in support of this bill. With that, I would sit for any questions.
Questions, Thank you. Any,
I do appreciate the smile.
well, you smile at us, so it's just polite to smile back. That's why we're smiling. Any other public comment? Okay. Okay, we've got another question for Deputy Director. Come on up, Jason, if you would, please. Representative Clausen.
Thank you, Mr. Chairman, Director, Deputy Director. So how big of a revenue generator is this? I mean, pointing and getting at it, is it worth your time to go after these halves? Or is it, I mean, is it a big, small?
Mr. Chairman, Representative Clausen, it's actually bigger than you'd think. When we were going through the effort to understand how we would utilize new personnel, we looked into the workload and this particular topic, subleasing, we review and approve or provide recommendations to the board for approval for over 400 subleases each year. And those are the ones that we know about. As Mr. McGagnon mentioned, might be many more that we don't know about. The revenue generated off of those ranges based on the agreements that they have out in the world, but anywhere from 500,000 to up to $1 million a year in revenue from this practice.
Okay. Representative Western.
Thank you, Mr. Chairman. Deputy Director Crowder, just to make sure I understand correctly. So it sounds like, and this ultimately reveals my ignorance, but there's plenty of these subleases where it's kind of a handshake deal. Technically, I have the state lease, someone pays me, pays me cash. You can lease your cows on there. It's an informal agreement, but there's no recorded transaction. Am I understanding that correctly?
Mr. Chairman, Representative Western, that could happen. So we have a document on our website that they could fill out. If it's just a handshake, they could reduce it to writing in that way and send it to us. But you're right, those things probably happen all over the state and we have no idea that they do occur. Unless somebody brings it to our attention, it's very difficult for us to find it.
All right. Well, we got one more here. Senator Kolb.
Thank you, Mr. Chairman. So I'm new to this whole topic, so excuse my ignorance. So we have a person who has a land lease for property and they can run their animals on it, right? Then we have a situation where they're only allowed to have so many animals on said property, right? On the animal units. So then they sublease it and then they bring in animals for however that happens. But they've already paid for a land lease with so many AU units on it, right? So I don't know, I tell you at this point, I'd be more amenable or wanted to hear your thoughts about upping the AU unit cost over trying to discern someone's coming and going to their private business when they lease land legally. And then now they have to pay an extra cost. And I understand what it's for, but why is that a good way of doing business? It sounds very messy to me. Could you explain why you think or you don't think this is a good thing to continue this type of policy for basically having an agreement with somebody for so many units of animals and then they bring in a contract with other animals and then you charge, I guess you get part of those said profits if you even know what they are. Could you enlighten me on why it's a good policy to continue? Thank you.
Mr. Chairman, Senator Kolb, I agree with Mr. McGagnon's assessment that this is a complex process. Every agreement's a little bit different. The land is a little bit different. How it's used is all a little bit different, but it's not a complexity that we're not accustomed to reviewing. We've got staff on hand that have been doing this for many years and they understand and recognize the different situations and it can apply some common sense to the complexity and come up with a good product going forward. They can also work with the lessee. There are many times where we have to have a conversation back and forth several times to get a full understanding of what the situation is on the ground and what the appropriate amount of excess rental is. And that's a normal thing for us to move forward. Why we do business this way? This is how the legislature has given us to do business. And so we'll keep moving forward on that. We've provided this committee as well as the Board of Land Commissioners one report that explicitly talked about how AUM fees are derived and how the market in the Western 11 states with other state landowning states, how they determine their AUM fees, and have suggested some changes to that to make it maybe closer to market to account for some of these one-offs, subleasing and other things, other management criteria that comes into a lease. That hasn't gained any traction with the committee or with the board to move forward in that realm. So we rely back on what the existing statute is, which is if you're making money from the state land above what you're paying us, you're making that money because of the state land, that the board or the beneficiaries is due half of that excess rental. So why we do it, we're required to. Is it a good business practice? It seems to be compensating the board and the beneficiaries appropriately for what's happening out there.
Representative Fortner.
Thank you, Mr. Chairman. I think there's a real risk of these sections that's out in the middle landlocked in these big branches that they're already leasing and you're binging them for another 50%. What's to say they're not just going to throw them up and say, you know what, we're done with you guys and graze them anyways. That's your risk that you guys are going to be taking right there. Thank you.
All right. Representative Clausen.
Mr. Chair, thank you, Mr. Chairman and Deputy Director. So maybe this is out in the weeds, but have you seen business arrangements where it seems like there's a loophole in this where you could just say in your arrangement, the state land is worth this much and the rest of the AUMs are worth this much? I guess, is that common or has that happened or are people generally more honest?
Mr. Chairman, all of our grazing lessees are extremely honest, but we have seen that once or twice. And, you know, we are very open with how to correct this issue. There's been a lot of scenarios brought up here. But essentially, as long as the lessee owns the livestock or owns some portion of the livestock, then there is no sublease. They have an interest in there. And that's what we tell them. If you're going to be a big corporation, have the corporation own a portion of the livestock. But in your scenario, that does happen. We try to catch it, and that's why when we ask for the sublease, we ask for the whole thing, so that we can understand exactly what's being had in that whole sublease and how the state land does participate in it.
Okay, thank you. So, committee, what's your pleasure? Pardon me? Well, I think we were done. Any other public comment? Oh, we do have more. Okay, come on up, Carl. I guess if you don't want to be called Secretary of State, I'll call you Carl.
Thank you, Mr. Chairman. You know, as I'm reading through this, we're talking about somebody who has a lease and they're just running somebody else's cattle. Whether with theirs or with some, you know, they've got a lease for grazing. And if we're not talking about a sublease, we just have an arrangement, you let your neighbor's cows on there, you know, then that wouldn't be a problem. I mean, because if they do a sublease and they're making money on it, then yeah, then they can share with the state that half. But just because they're running somebody else's cattle on there, I'll tell you, I got somebody here who's known to this committee that where his horse ran on my grazing for years. I didn't charge him a dime. Last winter, when there was no, I couldn't get hay, I had a neighbor who says, hey, I've got a field out here, just bring your horses over and they can have at it. He didn't charge me a dime. But if they charge even within the terms of the lease here, and just say, you know, hey, I can run 40 cows on this, but I've only got 20. So if you want to put 20 cows on there, that's within the terms of the lease with the state. And if there's no increase to me for doing it, or they're paying half of what that lease is because they got half the cows, then I think this is a good bill. And I think you guys should consider pushing this through. Thank you.
Committee questions? Thank you, sir. Any other public comment? Okay, now committee, what's your pleasure? Move the bill. Second. Seconded by Cost. Discussion on the bill. Go ahead. Chairman.
Okay, Mr. Chairman, I move that we amend the bill on page 2, line 20, strike is responsible for providing care and insert retains full management and responsibility. So the last portion of the sentence would read, but for which the lessee retains full management and responsibility to graze on the lands.
Okay. Seconded on the amendment. All those in favor of the amendment, say aye.
Aye.
Opposed? Okay, that amendment passes. Any further changes? Any further discussion? All right, I think we're ready to vote. Roll call.
Mr. Chairman, this is a roll call vote for 23 LSO 204, state lands grazing of non-owned livestock as amended. Senator French. Senator Kolb. Senator Cost. Senator Wasserberger. Representative Blackburn. Representative Clausen. Representative Fortner. Representative Heiner. Representative Larson. Representative Western. Representative Worf. Representative Winter. Co-Chairman Boner. Chairman Eklund.
Aye.
Mr. Chairman, we have 9 ayes, 5 noes.
All right, committee, the next bill for our consideration. Wait a minute here. Is state lands, use of land qualifications and requirements. Come on up, Luke.
Mr. Chairman, committee, Luke Plum, LSO, here to briefly discuss 23 LSO 0205. This is state lands use of qualification requirements. In this bill, currently the requirement that an applicant have actual and necessary use for the lands was found in 36.5.105, which specifically addressed the criteria for leasing. This bill would move it up into 101, which is more specifically on the qualifications for leasing. And so it just moves that language and has actual and necessary use for the land up into the very first subsection of the leasing statutes. And so that you would be required, a person would be required to, they're qualified to lease state lands if they've reached the age of majority, if they're a citizen or declare an intention to become a citizen of the United States, and has actual and necessary use for the land. And so this just makes it that every person who is leasing would be required to have, to be able to say that they have the actual and necessary use. And just briefly, if I may, Mr. Chairman, is just address briefly address the amendments that were provided by the Office of State Lands and Investments. I can certainly see that their suggestion is to move it into its own subsection within the criteria for leasing. Once again, the thought there about putting into 101 for the qualifications is even within 105, which is the criteria, it references back to what, section 101, specifically that those are the basic qualifications that every person must meet. Within 105, that is specifically just other criteria in addition to 101. And so that was just the thought there. If the committee were to, if it be the committee's desire to perhaps move the section that requires an applicant or a person to have actual and necessary use for the land or forage into, to keep that as its own subsection within 36.5.105, would just strongly recommend that it not be moved in as what would be a new subsection B, just because that would create issues with references throughout the statute. you know, everything currently, whatever is currently B may be referenced somewhere else. So it would be better, it would just be within LSO's norms, and just to try and make it a little bit simpler to put the new subsection at the end, if that makes sense. But essentially, yes, the point of this is just to move a basic qualification to lease state lands is that you have actual and necessary use for the land. And so that's primarily what the bill draft does, and I would stand for any questions.
Questions, committee? Okay, yes. Senator Bowman.
Okay, so you have this in 101, which it's my understanding it applies to all leases, not just ag and grazing leases. Is that correct understanding? And if so, wouldn't it, if we're only trying to affect ag and grazing leases, would that not be a better fit in 103, which looks like deals specifically with ag and grazing leases? So just want to make sure I understand the effect of the bill as it's written. Does 101 speak specifically to ag and grazing, or is it just for anybody who wants to lease the land for anything? Could it be an oil and gas company, for example?
I think Chairman Eklund and Co-Chairman Boner, I think certainly I can understand you read that because it is just in the leasing generally provision. So if you do want to make it specifically towards agricultural leasing, it may be more appropriate to move into 103.
And go ahead. And to be clear, I'm not sure that would have, I can't think of a negative effect that would have on any other type of leasing, but it's just, I'm a little uncertain because I just don't know. And maybe that'd be a question for the agency, you know, is there a lease that we give out that does not have actual necessary use, and what would we be affecting if we made a general requirement outside of just ag and grazing? So it's just a question that I think I need answered before we proceed too far with this bill.
All right. Thank you. So, Office of State Lands, will you come on up, please?
Mr. Chairman. Again, Jennifer Scoggin, Director of State Lands and Investments, and Jason Crowder, Deputy Director. I think Co-Chairman Boner sort of hit the issue on the head for us. We agree that the qualification is specific to grazing and agricultural purposes. And so that's why we proposed the amendment that we did, and Jason can get into that here in a second. But by not limiting it, by making the qualification for all leasing situations, that may prevent us from doing something like conservation leases in the future, things like that, where there's not an actual and necessary use. Although I guess you could argue that maybe that is an actual and necessary use. But with that, I would turn it over to Jason. He's worked through our proposed amendment here.
Thank you, Mr. Chairman. As the director mentioned, 36.5.101 is a leasing generally provision, and it doesn't apply all the way to mineral leases, but it does apply over to commercial leases or recreational leases or things like that. Sometimes those leases get to be speculative and they never get built. So having an actual necessary use requirement there is going to be problematic, especially as we move forward in the idea of conservation leasing, if we do something like that, or some other habitat type leasing scenario. That bar may be hard to meet. The other thing is, you know, we issue leases for grazing and agricultural purposes for that purpose. And the board in its rules has stated that the lease purpose for a grazing and agricultural lease is, I'll just read it for you. The board may lease suitable state land for grazing and livestock, production of crops, and other agricultural purposes under the provisions of this chapter. Meaning that is the purpose of the lease. And if you don't do it or operate the lease for that purpose, then you don't get this lease, or you don't get to retain it. So having actual necessary use crystallizes that perception, I guess, that we intend these lands to be used for livestock grazing, not set aside for any purpose. So it's a fine conversation to move forward, but I just want to make sure the committee's aware that the board has defined that. The committee should also have received inside the packet that we provided a set of amendments to correct the issue. I have it as page number 5 at the bottom of the amendment. And it does exactly what LSO asked not to do. And I apologize for that, but it creates a new subsection B within 36.5.105. To be very clear, when we're talking about leasing for grazing and agricultural purposes, these certain criteria apply. They apply for vacant land leasing, they apply for renewing leases, and then, not only and then, but on top of that, the core requirement is that you have actual and necessary use for the forage. So in our mind, that's the appropriate place to put it. Of course, if the committee feels another place to put it would be more beneficial, we can discuss that and understand what the impacts might be there. Throughout our amendment, our proposed amendment, all we do is insert that new subsection B, renumber as appropriate, and then remove any other references back to actual and necessary use of the forage because it's already a core requirement or a core qualification. With that, Mr. Chairman, I'm happy to answer any questions.
Questions, committee? Yes, go ahead. Representative Clausen.
Mr. Chairman, Deputy Director, so I guess this is walking the line. I assume this qualifier would disqualify someone wanting to lease for a conservation because it's necessary use. Have you been approached? Is there demand for people? I can see all kinds of problems with a conservation lease plopping down in the middle of something that's unfenced. Is there demand for that sort of thing? And does this qualifier knock that out?
Mr. Chairman, Representative Clausen, and Jason can tag on here too. But in our proposal process that we've been navigating in Teton County, there is a demand, if you will, for conservation leasing and the ability to pay or to remunerate the trust beneficiaries for leaving something sort of in its natural state for conservation purposes. So that's one place where we have seen it. And in the past, it's my understanding that we have had some special interest groups that have come and wanted to enter into a grazing lease in order to preserve the surface in more of a conservation type scenario. And I think we've been reluctant to do that because of the requirement that they have an actual and necessary use. And does a conservation bend, if you will, does that satisfy that? I don't know. Jason, do you want to tag on to that?
Sure, Mr. Chairman, Representative Clausen, it's a good point. And one of the reasons why we wanted to make sure that this provision was specific to agriculture and grazing. Having a purpose for ag and grazing leases be ag and grazing, and then crystallizing it in this way punts the rest of those conversations into a different leasing vehicle. Meaning that we move them to the commercial lease realm through either a temporary use permit or a special use lease to have that kind of activity. And at that point, we can layer on top of each other these leases. So you can have a grazing lease and a conservation lease at the same time, because as Jen mentioned, a lot of the interest in Teton County, and we're seeing it in the Red Desert too, especially with oil and gas development, is they're seeking to conserve a very unique or special habitat type from oil and gas development or from some impact the viewshed may experience because of oil and gas development. So if we put it into that other realm, we can still have grazing, but we can also have a lease that conserves or sets aside or opens green space, however you like to say it, but we can stack the two on top of each other. That would be my response.
Follow up.
Mr. Chairman, Director, so it seems like it's just about an inch away from being able to put a conservation on a mineral lease, justifying carbon or something like that. I mean, have those conversations been, is there a market for that? Are those conversations been had?
Mr. Chairman, Representative Clausen, they have been had. And in fact, it's only been the last couple oil and gas lease sales where the conversation hasn't been had, but sometimes we have the lease sales in sensitive areas where people would like to see them protected. one of the other benefits I should have mentioned about being in a special use lease scenario is that you have a lessee consent required in that process. And we'll get to that in a later bill, and I provided a handout to show you that. But any new user, a conservation lease on top of a grazing lease, the conservation lease being the new user, needs to approach that existing lessee and get their consent for the new use. They may not get their consent, and then we can go through a process where the board can determine if they can both live together or not. But it's not a, just because you apply for a conservation lease, do you set aside everything else? The conversation in those oil and gas scenarios was that we have this very important aspect that needs conserved in the perceived eye of somebody else. But the board said our revenue generating responsibility can also be done in a reasonable and sustainable way that won't harm that or may not harm that if we place certain environmental steps on the lease. And it felt comfortable moving forward with that. So I don't want you to get the impression that just because somebody comes to us and says, set aside that acre, that's what the board can do. It has a lot of avenues it can go down to try to get everybody's interests aligned.
Mr. Chairman and Deputy, this, I guess you don't have to answer this one if you don't want, but if we move this statute or this qualifier from one section of statute to the other, are we opening that can of worms for the conservation? It's a priority over grazing, over mineral. I mean, is that a risk here?
Mr. Chairman, from my perspective, I think the risk is already there. Like I said, we only give grazing and ag leases to grazing and ag purposes. Having this qualifier in there only crystallizes that. So anybody right now, if the board was ready, willing, and able to move forward with a conservation lease, could apply for that and do that. I'll state that we do have one quote conservation lease in the state right now, and you could probably expand that a little bit. But the one that's directly in line for that definition would be a sage grouse mitigation bank in the center of the state. It's a very large lease, but it's intended to set aside oil and gas development for sage grouse habitat promotion. We also actively lease with the Game and Fish Department to set aside forage from cattle grazing for habitat leasing or habitat forage conservation for wildlife. So it's already occurring, I guess is my response.
Chairman Boner.
Yeah, so just to make sure I understand, but basically what this bill would read is you're not going to have a conservation easement or lease under the guise of an ag lease, right? That's what we're bifurcating. So at least the board can know and make an appropriate decision. I think that's the point of the bill is it just, say what it is, not trying to determine any outcomes, unless we keep it the way it is. It seems like we might, if that's a policy decision the committee wants to make, that'd be, you keep the bill as it is and they have to have actual necessary use for everything. Of course, that ups a few apple carts. So just, is that a correct understanding?
Mr. Chairman, that's correct, Mr. Co-Chairman, and I would just emphasize too that with respect to conservation, we have not issued easements, in perpetuity forever and ever. It's just been, we've been looking at the possibility of, as the deputy was talking about, a special use lease for a time certain, but we haven't fleshed out any programs or anything. This is more to define, as you were saying, call an ag lease and not using it as a vehicle for something else.
Okay. Any other questions? Thank you. Public comment.
Thank you, Mr. Chairman. Again, Jim McGagnon, Wyoming Stock Road Association. This is a change that we have sought and fully support the bill as amended with the language provided by the State Land Office. And we believe this returns the use of that phrase of actual necessary use to its original intent when this very committee put that in back in 2004 or whenever that was. Takes me back to Senator Geis because those were his words, frankly, that the intent was to preclude outside groups from coming and leasing state lands with no intent to graze, in fact, with the intent to make sure that they weren't grazed. If they want to propose some other type of a lease to accomplish that objective, the law allows for it, but not to abuse a grazing lease with no intent to ever graze on it. That's what the scenario that led to this, and we believe that this language as proposed by the land office in this bill meets that purpose, and would urge your support.
So in fact, the change did do exactly the opposite of what the intention was. It actually opened it up to where it could be other uses besides grazing. Am I correct on that?
The change that was put in back then with the addition of the language actual necessary use, unfortunately got put in a way that it only applied to vacant land. And the very scenario that led to putting that language in did not involve vacant land. It involved land that had current leases on it, and a non-ag group came in, an anti-grazing group came in and bid competitively against those leases as great for grazing leases. That's what led to this. But unfortunately, the way it got worded in the statute, it appeared that it only applied to vacant lands, and that's what we're attempting to correct here.
Okay. Thank you. Committee, yes. Senator Boner.
Yeah, I'd point out in the current subparagraph C, it talks about a competitive bid and so I think it's probably a direct response to that particular situation. What this bill would do would make it broad for every ag and grazing lease, whether you currently have it or not. And so I think that's an important distinction. There's still some gaps there that I think we need to close to not respond to a specific situation, but make sure that it applies to every situation.
It applies to agricultural lands, yes.
Yeah.
Mhm. Yeah, not, when we looked at the bill, quite frankly, even certainly we did not support having it in 36.5.101 because, as you already addressed, Senator Boner, that gave it broad application beyond grazing. In 105, one way to have done it a different way, but I think this is a very good way too, would have been to leave the action necessary language in there on lines 18 and 19 and just strike the word vacant in line 16. And that would have made it apply to all lands that are covered by 36.5.105B, which is about grazing. That's another way to do it without adding a sentence, but either way is very satisfactory from our perspective.
Representative Clausen.
Mr. Chairman, Mr. McGagna, do you see any unintended consequences if we left the struck language on line 18 and 19 and then added the other in the suggested
sorry.
place? So you leave the has actual and necessary use for the land in the leasing provisions too? Or is it unnecessary?
I'm sorry,
That's
Mr.
what-
Chairman, Representative Clausen, on lines 18 and 19, reinsert the language that was stricken and do what else?
And then put the other language in wherever. I haven't read the statute in entirety, and I know this stuff bounces back around from working in these
So-
sections. But is there unintended consequences if you left the language that's struck and put the language in the other?
In the
I
other,
haven't read it in its entirety, and I assume you have, and that's.
yeah, I mean, as long as it stays in 36.5.105, I don't think it matters. It would seem if you did both that it's a bit repetitive, but there's no harm done by that. I would defer to the committee on that, but.
Okay. Committee, other questions? All right. Thank you.
Thank you, Mr. Chairman.
Other public comment? Come on up, Mr. Allred.
Thank you, Mr. Chairman. I would agree that putting that wording in 105 and the proposed amendment would be better. The current draft right now, you've got you'd have to remove one of them because it's redundant in there on this draft. And I do think that the amendment is better. But do want to say is, as they were talking a lot about these conservation easements. We had one that came up where we approved a couple conservation easements, allowed the lessee to put conservation easements on the for grasslands on that state land, which I spoke against. I voted against that, but I lost that fight. One thing that I have a problem with is putting an easement conservation or something on that allowed the federal government to have control of our state lands. They have enough control already. And I don't think that's a good thing for them to have control of our state lands anymore. So those conservation easements, you know, there's something to think about, because when you sign one of those, you give up position, you give up first position on that land. And I don't think that should be allowed with our state lands. The state should have first position and control of that state land, whether it's to a leasee or however you want to look at it. But to give that position and that control up, whether it's to the federal government or to a private conservation group, I think that's a mistake, and I don't think that should be allowed on our state lands, period. But that's just my comment.
Okay. Committee. Thank you. Now you see, nobody smiled.
Because I'm a little perplexed. Brett Moline, Wyoming Farm Bureau Federation. And this is a policy decision you folks are gonna have to make, putting it in specific. That's why you guys get the big bucks, both of them. It's a policy decision. Do you want this to just apply to the agriculture and grazing? If you put it in, if I understand it correctly, if you put this in where the bill is drafted, it'll affect every lease. Is that a bad thing? In my quick perusal, I don't think it is. I think putting it in where the draft bill is without the amendment is not a bad thing. And this is going to come down to how you define actual and necessary use of the land. If as a policy decision through the state land, the SLIB board, state to do that lease, if they determine that conservation is an actual and necessary use of the land, that lease would qualify. So my opinion is leaving it in where the bill is drafted is the appropriate place, because what if somebody wants to come in and lease up the mineral and then has no intent to ever utilize it? They have a lease, but they have no actual and necessary use. This, putting it where it is now, would cover that. I like it where it is now. I can live with putting it in the other place. But as far as being all encompassing and protecting the economy generated by those lands, I think this is probably the more appropriate place. With that, Mr. Chairman, I'll smile and hope to get one back. I would sit for any questions, sir.
Okay. Committee, questions? So it's getting along in the afternoon and I'm a little bit confused, I guess, myself. We talked about this was only going to be dealing with the ag lands. And yet part of it in the bill as drafted would have it in general leasing. If we leave it as drafted, we would still have other uses in general leasing and not just ag lands. Am I correct on this? Maybe Luke, can you help me a little with that?
Chairman Eklund, yes, I think this would, where it currently is in 101 would have a broader effect. I would note don't know if it, yeah, I believe Deputy Director Crowder may have mentioned, I don't know if it actually has applicability to all the mineral leases, but yes, would have, if it's in 101, it may be more inclusive to include the commercial or the recreational, other types of leasing. And then moving it into 105, as OSLI has recommended, would limit it more so specifically to the agricultural and grazing leases.
Okay, and so your preference would be to keep it in the general leasing part, the 365101 as
Mr.
well,
Chair-
rather than, okay, Go
Mr.
ahead.
Chairman, yes.
all right. Okay, committee, any further discussion on this? All right, I'm not sure myself now,
Well,
which I prefer.
Mr. Chairman,
I-
sometimes my confusion is contagious. And if I did that, I apologize, but
Yeah,
having it in a more general application, in my estimation, would be a better policy choice. Not that, leaving it specific to agriculture would not be a bad choice. That would protect my members. But leaving it in the general category perhaps could be a broader protection.
okay. All right, well, thank you. Oh, we've got another question. Go ahead. Senator Cole.
Thank you, Mr. Chairman. Well, at the risk of, I guess, looking at it maybe slightly different and hearing your opinion, we're wrong. We put it in a general section and some smart attorney out there somewhere uses it against us. It could have ramifications that are, far worse than just dealing with the ag section, say making a mistake there. Would it be better to try it, in your opinion, and just ag and categorize, and put some sideboards on it so it isn't so broad? I'm afraid of unintended consequences. What do you think about unintended consequences when it comes to maybe some attorneys that are probably smarter than both of us? Or at least me. Thank you.
Mr. Chairman, Senator, that is a risk. I will concede that is a risk. But it also, I think it is, if the policy decision is wrong, and that is a risk you make with every policy decision you make. As a legislature, there's been things that have been overturned because of lawsuits, but having this as a general sense, in my opinion, would be a good thing. I am not against leaving it specific to agriculture. That is probably a more sure, good decision. But a better decision, in my opinion, would be to leave it general. But that, I can live with either decision. I hope I'm waffling good enough that to not be against limiting it to agriculture, but I don't think expanding it would be a bad thing.
Better turn the mic on. Thank you, sir. Further public comment? So. Committee, what's your pleasure? Bill's been moved. Seconded by Cost. Discussion
Mr.
on,
Chairman, I'm sorry, we didn't catch who moved it.
uh,
Chairman Booth. Okay.
yeah, Senator Boner. So discussion on the bill changes. Yeah, Senator Cost.
Thank you, Mr. Chairman. I'm gonna throw this the best way I know how to throw it, and I might be below the lawyers for sure. Our constitutional requirement is to get the most for the funding out of our lands, right? And so if we eliminate other opportunities and only look at it in terms of agriculture, does that limit the amount of funding we can receive for that land compared to if we keep it in a more broad open term? I certainly understand the situation by saying we don't maybe necessarily want some of the options that might open, but at the same time, if we're bound to our constitution, don't we need to try to get the most money for that land? And if that means a conservation or somebody out there that wants to look at it in a different way than we do, and they're willing to put the money up, are we violating what our constitution's asking us to do? Would be my question.
I should turn this on. Are you referencing the idea of keeping it in the general leasing part? Or, so what we're doing here is trying to sort out which way we want to go, with the amendment or without the amendment. Go ahead.
Thank you, Mr. Chairman. I'm saying maybe we do need to start out with this in the general. And then if it appears that this isn't the best place for it because of some other reason, then go move it down to a more restricted area. But I'm a little worried about whether we're actually looking for the best interest for the most money, or are we looking in a different way? And I'm caught between a rock and a hard spot because I can see both sides. And at the same time, I'm not sure I like the options either way in some ways. So I'm saying maybe we need to start out with the 101 rather than the 105.
Okay. Committee, yeah. Representative Heiner.
Thank you, Mr. Chairman. I also agree that we should keep this in the more general sense. I think we all see the influence that outside money can have on the state and the resources of the state. And there's a tremendous amount of outside money, and conservation easements is an avenue which they could use in the future to lock up our land within the state and not allow us to use it for the purpose that it was, that we as citizens of the state would like it to be used for. The conservation momentum is out there and it's real. And I don't want us to be chasing dollars and give up some of the opportunities we have to graze land, to develop the resources, the mineral resources of the land, just because we're fixated on a conservation easement that actually brings in a little bit more revenue at the time. So I believe that we should put it in the general portion of this bill, leave it as is without amending, so that we focus on keeping Wyoming as Wyoming and not let it become a conservation easement for the global elitists to be able to celebrate that they're keeping wide open spaces in Wyoming with their money that they're bringing into the state.
Okay. Yes, Senator Kolb.
Thank you, Mr. Chairman. Well, that probably typifies my, the last comment. I think the danger is just that. If you have a conservation group, they're going to say that is a use for that land, and they will lock it up. That is currently what we have, as I understand it, is constitutional, what a statute's currently written. We change it, we're opening the door for someone to make the argument that I just made, to say that is a use for the land. And they will make the odd and to the contrary of what was, we think there would be grazing or minerals extraction or whatever. They're going to say, no, the best use of this land is for conservation. And they'll in fact lock it up. I think that lies the danger of broadening this up too far. So I'm not in favor of that. I'm in favor of making it under 105 instead of what it's currently listed as a broad sense. Thank you, Mr. Chairman, for my chance to comment. And I would make that amendment that we change that to 105, 36.5.105 and reference that.
So are you going with the whole amendment as we had gone through it that was brought by state lands?
Yes, Mr. Chairman.
Okay. Committee, are you clear on what we're doing? The amendment is it seconded? Seconded by Blackburn. Any discussion on it? Yes, go ahead, Senator Boner.
Just so obviously the choice here is if we vote for it, we're gonna take it back to the original intent and discussion we had, simply to make sure that we clear up that when you apply for ag and grazing lease, it has to be used for that purpose. And if you vote no, you're making a much broader statement that you have to have actual necessary use for the land. And so before I vote, I need to know, it probably needs state lands help a little bit. If we keep it as is, as a general requirement, what other leases are we affecting besides ag and grazing leases? I could use a refresher on that. I think it's important we understand the impact before we move forward one or the other.
Mr. Chairman, Mr. Co-Chair, I think that's a great question again. So if it's in the broad sense, if it's in 101, you're spreading it over to commercial leases. We only have a limited number of buckets we use as vehicles for leasing: agriculture and grazing, temporary use permits, special use leases, and then oil and gas or mineral development, but this doesn't touch those. So of those three buckets, you touch all three of them in 101. In 105, you just touch the ag and grazing leases. And we've all stated what that is. The uses within our commercial side of the house that are not active, like a tank battery or some kind of ancillary oil and gas development, would be the game and fish habitat leasing that I spoke about, the sage grouse mitigation bank lease in the center of the state. To go even further than that, we have a lease with the City of Lander Economic Development Group, where they have set aside a certain set of acres to try to generate economic development, bring businesses into the city of Lander. They've had, unfortunately, a slow time in getting those businesses in. We've gotten 2 or 3, but it has a capacity for up to 12 or 15. But that's just a set that land there and make it available for economic development. It could have an impact on something like that. So, Mr. Chairman, off the top of my head, that's what's coming forward.
Are you clear? Go ahead.
Yeah,
Senator
and that
Carlos.
those sort of, I guess, practical examples do help me. And so I'm assuming that we could always, if we vote for the amendment, we can always vote to bring it back the way it is right now. It seems well within the title of the bill to make this choice at a later time. For me, I'll be voting yes, Mr. Chairman, on the amendment, because I think it's important to start with what we know. And if we want to expand it later, once we talk to those other entities like Game and Fish and, Lander Economic Development, we can always change it back to 101 as it goes through the process. But for now, I think I'll take the more incremental approach and make sure that we tighten up our ag and grazing lease procedures for now. Make sure they're used for what they're supposed to be used for. We're not having any nefarious activity within those leases. And then we can assess whether we want to expand it without, affecting what sounds like to me to be not, purposes that could be beneficial as well, that we don't necessarily want to exclude, just because we're worried about, folks coming in and taking up every last school section and saying you can't graze cattle and sheep here. So anyways, I'll be voting yes for that reason. Either way, I think it's going to be a good bill. So.
Okay, any further discussion? So we're voting on the amendment as presented to us on this sheet of paper. All those in favor say aye.
Aye.
Opposed? If division called, all those in favor, raise your hand. Okay, all those opposed, raise your hand. 7. Oh dear, I've got to vote then. I'm probably in favor of it, of the amendment. So that would be. Is that an 8-7? That was my count.
Chairman, I believe it'd be 8-6.
Oh,
If you're in favor, it would be 8-6 in favor of the amendment.
Here. Okay, all right. So, all right, the amendment passes. Is there any further discussion on the bill? Yes. Go ahead. Heather.
Mr. Chairman.
Yep.
Yes, we were both actually going to ask the same thing as to whether the committee wants the amendment as inserting it as a new subsection B and renumbering everything subsequent, or inserting it as a at the end, which would be a J.
I thought it was inserted as a B. I'm not sure what you were, I guess I don't understand. Go through it again.
Hello, Chairman, Chairman Eklund. So previously, when I had discussed the bill, I just had mentioned potentially, OSLI had inserted this as a new B and then renumbering the rest of the subsection. It was just a thought to perhaps have this new language that would be inserted at the end of 36.5.105, which would be a new subsection J, just to be able to preserve any other statutory references to the existing B, C, D, if you understand what I mean, because this would change it B, and then everything after that would be changed. So it's just moving it from up into B down to J, just to preserve some of those things, if the committee is up for that, or it can remain as B. Just wanted to clarify what that preference was.
Go ahead, Senator.
We'll defer to Senator McCall, but I didn't hear it as a part of the motion that we would defy regular LSO drafting techniques. So I think you got some leeway there to make whatever makes sense, but.
Thank you, Chairman.
Is everybody okay with that? We already voted on it, but we'll defer to the LSO to draft it the way their statute law is usually written. You good with that? I think we're good with that then. All right. Next bill for our consideration, right? Oh, oops. I've done this before. Okay, roll call, please.
Mr. Chairman, this is a roll call vote for 23 LSO 205, State Lands Use of Land Qualification Requirements as amended. Senator French. Senator Cole.
Aye.
Senator Cost. Senator Wasserberger. Representative Blackburn. Representative Clausen.
Aye.
Representative Fortner. Representative Heiner. Representative Larson. Representative Western. Representative Ward. Representative Winter. Co-Chairman Boner.
Aye.
Chairman Eklund.
Aye.
Mr. Chairman, we have 11 ayes, 3 noes.
Okay. All right, now we're ready for the next bill for consideration. Hi. Go ahead when you're ready, Heather.
Okay, thank you, Mr. Chairman. Heather Jarvis for the Legislative Service Office. And I have, and hopefully you have before you 23 LSO-0200, Working Draft 06. And in addition to that, there's also a memorandum that you have following it, or that came in your other subsequent materials. So the 23 LSO 200 bill draft provides priority considerations for land exchanges and requires notice and opportunity to comment before completing an exchange, and then specifies applicability. So the bill goes into the section 36-1-111, a intro, and creates a new subsection B. So what we're going to do is, you see on page 2, the insertion into 36-1-111 subsection A is the requirement for the director to provide notice and opportunity to provide the board comments, provide and to new interested parties, including leaseholders of the lands to be exchanged, owners of adjoining lands, and municipal and county elected officials and state legislators from the affected county. So that notice requirement would become part of the process required before an exchange could be completed. And then the new subsection B, it inserts this section that says, when deciding among parcels, basically, it needs to be, the following need to be considered. So you'll see at the bottom of page 3. Well, first of all, there is the reference to the very fact, and this is what the memo refers to, is that any parcel has to inure to the benefit of trust beneficiaries, and then to accomplish as many of the following as possible. And that's where we're at the bottom of page 3. The first one is an exchange where the resulting state lands, if the exchange is completed, are wholly within the same county. Next, another priority is an exchange that allows for increased public access to state lands. And another criteria on page 4 is an exchange that consolidates state ownership to create contiguous state land parcels. And then another criterion, which actually kind of refers back to that which was inserted into subsection A, which is if there have been expressed support from any of those parties who had been requested for comment or given the opportunity for comment. And then the next section, or actually before we leave those, I did want to mention, as per the bill drafting conventions, if a section is not amended, it's not included in the bill, but I think that this committee is familiar with the rest of 36-1-111, which is at the end of A intro. You'll note on page 3, line 8, you'll note that there is a colon there, and the committee is probably quite familiar with the criteria that already exist, which are the I don't just have them memorized, but they're in existing law as far as to what the criteria that an exchange is already supposed to meet. So I just wanted to say that this interplays, the new subsection B interplays with you're adding these to those criteria. And then section 2, now I'm moving back to page 4. It says that this act shall apply to any exchange that is not completed on or before the effective date of this act. And then section 3 is an immediate effective date. And then the memorandum that you have, and it was sent, it was on your desk when you started this meeting today, and then it was also sent out a week or so ago. Has this is just a reminder to the committee of the trust obligations of the state to its state lands to inure to the benefit of the state trust beneficiaries. And that is as I don't know to what extent you all want me to go through the memo, but the focus is that state trust beneficiaries is a distinction and has been a distinction in the courts made between the inure to the benefit of the state, which is different than inure to the state trust beneficiaries. And so the state lands need to be managed to inure to the benefit of state trust beneficiaries, not just to the state. And there are some, I can stand for questions or go into that further if the committee wishes.
Committee questions? Yeah, Senator Kolb.
Thank you, Mr. Chairman. I had just a question about page 4, I guess lines 5 through 9, where it mentions express support from any interested parties, and it goes on including, and it goes down to saying state legislators from the affected county. Legality of that, I didn't realize that a state legislator had any authority beyond the legislature there, like the House or Senate they belong to. So I just wondered why that was there. Could you explain why, I guess what the power or what the I don't know, deference a state legislator would have individually towards this situation here, as it's mentioned, how it would actually work?
Mr. Chairman, Senator Kolb, that is just an expansion of possible interested parties to an exchange. And and if they're within the same county, and given that one of the criteria is an exchange, there's priority to an exchange that is wholly within the same county. That was where that came from as far as when the suggestion was given to include state legislators from the same county.
I will follow up. Yeah, follow up to that. I understand Board of County Commissioners, right? Because they're elected to the said county to be involved with those kind of decisions primarily, but I say I'm still a little miffed on why the legislators are involved. I mean, I understand what you said. Thank you for doing your best to explain that, but I just don't see how county officials, county commissioners in particular, are on the same level as an individual state legislator would be when it comes to county matters because they weren't elected to represent the entire county typically. Thank you.
Senator Boner.
Yeah, Mr. Chairman, and just as a review for the idea behind the bill, the focus here is to save staff time, because that's what we've heard, spend a lot of time on these exchanges. And there's a lot of analysis that goes into them. However, there's no real opportunity for public input except at the end. And so what we're trying to avoid is a circumstance where the state lands office and the board goes through all this process only to have it be at the end found that's an incredibly unpopular proposal, and it ends up they're voting against it. I can think of one in Platte County recently that went down in flames for that reason, and it had a lot of these characteristics. It wasn't popular with the folks who would be affected by it. It is from multiple counties. So the idea behind the bill is to make sure that we prioritize the exchanges that are more likely to succeed and not waste time on those that are not. So just to remind, that's why it's there. It's meant to get some sort of gauge as to the local response to the proposed land exchange, if it exists, so that the board can make that decision without going fully public with all the details of the exchange and probably ruin the opportunity for the exchange in the process. So having state legislators there is not a make or break thing. But we can tell when we have a former commissioner on this committee, I think, but that's the intent, to make sure you get some sort of local input from folks who are directly affected or have knowledge of it. So whether state legislators stay in there or not, it's not now a deal breaker, but that's the intent. So.
Mr. Chairman.
Yes, go ahead.
And one additional clarification on that, the idea to try to delineate a bit of who the interested parties are. However, I think a correction, sometimes when you hear something out loud, it sounds a little, you realize the mistake, because I have had drafted it as parties, and they were not parties. It should say persons in both of these instances, just trying to limit who some of the interested persons are, so that there's not the world of interested persons out there to which OSLI has to. But that's the subsequent list of including, and then all of those after it was just to try to limit the world to whom they needed to send it. Of interested persons though, but it should be persons, not parties, because they're not necessarily parties to a lease.
How many places do we have parties instead of persons? Just one?
Mr. Chairman, page
Good.
2, line 14, and page 4, line 6.
All right. Further discussion or questions on the bill, committee? Yes, Representative Western.
Thank you, Mr. Chairman. Going back to Senator Boner's point, I know we obviously were in a great deal of overlap. The concern is, as I see right now, and I think there's a lot of good stuff here for sure, but really more has to do on page 2 when it says provide notice and opportunity. Conceptually, I think that's excellent, but kind of the problem we ran into last year is, when does that notice and opportunity happen in that process? Because right near it's putting up no sideboards on when that does happen. It leaves the process as is right now in terms of disclosure and public inclusion, which I think was kind of part of the process. So just that's an observation and a concern I do have with it. But again, I think there's definitely some good stuff in here too.
Representative Fortner.
Thank you, Mr. Chairman. Over on page 2, down on line 7, it says appraisal and evaluation. Who's doing the appraisals? Is it an independent appraiser or is there going to be somebody from the state that does that? Who does that?
Mr.
I'm
Chairman,
not sure. Go ahead.
I do believe that the Office of State Lands can answer the specifics of that, but I wanted to direct you to one of the requirements from the legislature for state lands, and this is in your memo, is the requirement that any state lands be only exchanged on a value for value basis. There we go. It's on page 2 of your memo. That an exchange is not the same as a sale and shall only be made value for value. So I do not think that that value always constitutes necessarily a dollar amount. There can be different purposes for value. However, as far as like an act who does the appraising, I think that someone else will have to respond to that.
It's existing law and it's already covered. We won't be covering it in the bill. Senator French.
Thank you, Mr. Chair. On page 4, 5 through 9, on owners of adjoining lands. So because you're talking about express support, can this sale or whatever exchange go through if you don't have all these people in agreement? Might have a neighbor that hates the guy that's proposing the exchange. Can it happen anyway?
Mr. Chairman, Senator French, yes, is the answer. And these criteria that are added are some additional things to take into consideration. The way it's worded on page 3 is that when deciding among parcels, that the board shall consider implementing land value for value exchanges that inure benefit for trust beneficiaries. Those are the 2 big constitutional criteria, and accomplish as many of the following as possible. And so that 4 that you just read, it's on page 4, as well as the 3 paragraphs even before it, are all just some additional considerations to help in the priority and considering which exchanges to move forward on.
Senator French.
Just follow up, because that's pretty strong language, isn't it? An exchange that receives express support, isn't that pretty strong? So you're saying it still can go through if they determine it's to the benefit of the state or whatever.
Mr. Chairman, it is conceivable that an exchange could go through without any of these, or it's conceivable that an exchange could go through that has, say, paragraph 1 and paragraph 3. So paragraph 1 is where the resulting state lands are wholly within the same county, and paragraph 3 is where the exchange consolidates state ownership in parcels, but that doesn't have 2 or 4. This is just saying as many as possible. However, let's say that parcel or an exchange with only those benefits 1 and 3, and yet it's being compared with an exchange that say has all 4 benefits. That would seem to be in favor of the one that maybe has the 4. However, then the first and foremost is always the land, the value for value, and the inuring to the benefit of the state trust beneficiaries. But these are only just as many of as their guidance as far as to encourage an exchange that has as many of these as possible, especially as in comparison with another one, for example.
All right, any other questions? Okay. Thank you. I think we're ready for Office of State Lands, if you'd like to come forward.
Mr. Chairman, thank you. So with respect to this bill draft, we don't believe that this bill is necessary. With the exception of proximity within the county, these are our existing trust land management objectives. As Heather mentioned, Wyoming Statute 36-1-111 already lays out sort of the high level criteria for exchanges. And from this statute, the board has formally adopted their trust land management objectives. And we've provided you with your handouts. I think it's page 6. It's a long, it's a board matter H-4, which was approved by the board on August 10th of 2005. And if you look through this, you'll see that the board set forth the trust land management objectives that are considered for all state trust land sales, acquisitions, exchanges, and long-term leasing proposals. The objectives are derived from applicable statutes, which are enumerated in the text there. And the proposals related to state lands, they don't need to meet all of the objectives. But the trust land management objectives, the first one is to better meet the beneficiary's short and or long-term objectives. And you'll see that in the board matter, it talks first about revenue, improving income generating potential, and doing that alone or in combination with other state trust lands. Single or multiple uses are considered. And then they look at investment. Is there an improvement on returns? Will it improve the portfolio diversification? Will it improve appreciation potential? Will it improve intrinsic natural resource value such as habitat, water, those sorts of things? The second one is to improve the manageability of the land asset. So again, we're looking to consolidate ownership patterns where possible. That makes the trust lands easier for us to keep track of and to manage. We also look for opportunities to leverage management resources of other agencies and entities such as Game and Fish. And then finally, the third trust land management principle is, or objective, is to meet specific school and or community needs. And we look at improving stability, providing growth opportunities, and improving access and recreational opportunities. So we believe that sort of the spirit of the changes in this proposed bill are already encompassed in the board's trust land management objectives. And as I mentioned, we evaluate these with respect to any transaction that involves the state trust lands, whether it's exchanges, sales, disposals, that sort of thing. So with that, I would turn it over to Deputy Director Crowder because we do have some proposed amendments related to the notice piece of that. We heard you last time with respect to concerns about notice, but Deputy.
Thank you. Mr. Chairman, quickly, I'll just run through the list of amendments. I didn't have a chance to type these out for you, so I'm just gonna explain them, I think. On page 2, line 13, where it speaks to the director provides notice and opportunity to provide the board comments to interested parties. That sentence seems a little confusing to us, and I'm not sure how to comply with that. So we'd offer the amendment of after the word opportunity on line 13 to delete to provide comments to interested parties and instead replace that to interested parties to provide comments to the board. Basically, as Representative Western said, allow the community and any interested folks to actually give those comments to the board to make that sentence a little more clear for us. The second amendment is on page 2 as well, line 14. After the word the, insert state lands. We've testified before trying to find leaseholders of any lands, including private lands or federal lands that we may be exchanging with could be a large task. And so we want to narrow that down to just leaseholders of the state lands involved in the transaction. On line 15, Mr. Chairman, we would ask, well, if we strike the word municipal and that might give a little bit more certainty as to who we are addressing in these comments. And very rarely do we have a piece of state lands within a municipal boundary. So striking that because we wouldn't know who to provide that notice to. And then on line 16 to delete the word officials and insert that with commissioners We weren't sure if the committee's intent here was to allow all the elected officials within a county to provide comment back to a transaction, or if you wanted to be specific to those county commissioners. And then, Mr. Chairman, on page 3, line 11. This again was a little bit confusing to us as far as how to manage it. So we are proposing that after the word exchange, obviously delete the S and make that just a singular reference. And then delete. Let me make sure I'm reading it. Exchange, delete S, delete the word same. I think yep, I lost myself there. I wrote down my notes wrong. I apologize, Mr. Chairman. Right, so the way the sentence reads now, if we have two competing exchanges on a particular parcel of state land, that we could look at the rest of these criteria or qualifying criteria to know which one to implement first or consider first. If that's the intent of the committee, we need to reword that to make sure it says the same parcel. If that's not the intent of the committee and it's talking about all the exchange proposals that we have on the table, then we need to reword that as well. And I didn't write that great on my notes. I apologize. And Mr. Chairman, that's all the amendments that we had.
So how might that read? Let's go back to that B, because I'm still reading it as a particular parcel. You indicated that's what we need to
Right.
be clear on.
And Mr. Chairman, after the word exchange, you could say the same parcel instead of a particular.
Okay,
Or if the intent is the opposite, to reword that to say possible exchange of any state lands.
Senator, go ahead.
Yeah, and the intent was the second that, you know, you have, say, 4 exchanges on the docket. You have to prioritize which ones you're gonna move forward first, I imagine. And that's, once again, hearing about the challenges you have with staff. And, you know, the fact is that I keep on hearing feedback that this is not the fastest process in state government. And so just trying to, idea is to prioritize the ones that are likely to succeed. Maybe a little bit simpler, meet more objectives, and I think it is important that we have it in the same county or something similar. The closer it is, the more chance it seems to have. But also the fourth element I think is really important too, which is that you have some gauge of the public reaction. Because the last thing we want is to go through the whole process. You don't have public comment to the end. I understand that with the previous bill, there's good reason for that. But we also don't want to waste staff time with an exchange that is almost certainly, you know, not likely to succeed, or at least give the board that information at some point before the end so they can make that determination. So just to be clear again, what the intent of the bill is, and I appreciate that feedback. That does help.
Mr. Chairman, I think that's all we have.
Okay, thank you. So we're ready for other public comment. Oh, we've got a question here. Hang on. Go ahead.
Thank you, Mr.
Representative
Chairman.
Reiner.
Director, in the rules and regulations of the Office of State Lands, Chapter 26, Section 4, it talks about how any individual, including the director, can nominate a parcel of land for disposal. And then it goes on to state that that list of Category 1 and Category 2 disposal lists is available to the public. Where is that? Where can the public find those disposal lists? I asked my assistant, Googled, and she wasn't able to find that. But it says it should be accessible to the public.
Mr. Chairman, Representative Heiner, they can call the Office of State Lands and request that from us.
So it's not published. It's something that has to go through a information request.
Excuse me, Mr. Chairman, Representative Heiner, I don't believe it needs to be a Public Records Act request sort of thing. I think if they just call and ask staff for it, and keep in mind, one list can be public, the other one cannot be. For purposes of an exchange, for instance, the parcels that are under consideration for acquisition are kept confidential until the board makes a decision on that. Did I get that right?
Yes, ma'am.
Okay.
The only addition I would have is that on our website are all of our active transactions. And it's not necessarily categorized in a list. It's just, these are all the active ones, which would fit the category 2 criteria.
Follow up.
Follow up. Thank you, Mr. Chairman. So category 1 is not available then? Because the way I read section 4 is anyone can nominate a parcel to be on the disposal list. And then it goes through the evaluation, and whether or not it progresses to category 2 is up to numerous factors. But it goes on that category 1 and until such time as it's moved to category 2, or after a year, it automatically drops off. But it also says that both of those categories are public information.
Mr. Chairman, I'd have to go back and review the exact language of the rules, but I believe it says that category 1 will be held in confidence until the board makes it public. And again, I need to read the exact language, but that's the intent, is it's in category 1 for a year, up to a year, pending the director's removal of it to category 2 and the board making it public. Happy to go through the rules and clarify where we're misspeaking, I suppose.
Okay. Representative Western.
Thank you, Mr. Chairman. Director Scoggins, are your records and anything that's pending in category 1 subject to open records requests?
Mr. Chairman, I'm not sure I understand the question. What do you mean, like an official request under the Public Records Act? Is
That would, Mr. Chairman, Director Scoggins, yes, similar to for a Freedom of Information Act request.
Mr. Chairman, Representative Western, I think I would have to look at the rules, but those things that are held in confidence or under confidentiality provisions until the board passes upon them, I do not believe that those are to be disclosed until that happens.
Chairman Pollock.
Go ahead.
Director Scoggins, sounds like you're not sure whether those are subject
Mr.
to
Chairman.
open records
Representative-
requests.
Representative Western, I'd have to look at the rules. I know that there's this category that is and that isn't, and I did not review those prior to me sitting here today. Deputy, do you know off the top of your head?
Mr. Chairman, Representative Western, I don't know the direct answer to that question. I do know that when we have a transaction that has an acquisition component and there's some risk to the value of that acquisition changing because of public disclosure, we're allowed to present that to the board in an executive session. If we're providing that information based on a public records request prior to that executive session, the same risk would apply in my opinion. So I don't know if we can answer your question directly, but that's the interpretation that we follow right now.
All right. Representative Fortner.
I don't agree with that one little bit. If there's a public records request and it's refused, that does away with our ability for accountability and transparency. I do not see how we put that kind of rule in place above the people of the state of Wyoming. I don't agree with that one bit. Thank you.
Okay.
Mr. Chairman, Representative Fortner, the way the rules are designed is to, as you might imagine, being the state, we're kind of handicapped, if you will, when it comes to doing land transactions. And so if people get word that we're looking at an exchange or an acquisition, there have been times where shenanigans occur and people can go over there and, buy and sell and run the price up and other things like that. And so it's largely to protect the state's ability to conduct land transactions as, on an even platform, an even basis. And so once a decision has been made to move forward, with the board, then those things become public. There's public comment period that occurs and people can weigh in on that. But those initial decisions, they are kept confidential. And it's my understanding that it's based on the executive session laws that allow pricing and aspects of real estate purchases to be kept in confidence pursuant to executive session rules.
Follow up.
In my opinion, this is where we let government run afoul on the rights of the people. The people are the boss of the government, not the government's the boss of the people. That's the way the Constitution is, and that's the way it should have been. We should have never let that get away from us, but evidently that's happened in the state of Wyoming. Thank you.
Mr. Chairman, Representative Fortner, it's my understanding too that on the private side, those folks who are interested in doing an exchange with the state, they don't necessarily want their business out there unless they know for sure that the state wants to go forward with an exchange or an acquisition or whatever the case may be. And so part of it, I think, is to protect the private parties too until decisions are made to move forward and then the public gets involved and can weigh in.
All right, well, thank you. We better move on with further public comment. Oh, Heather, I'm sorry.
Mr. Chairman, I just wanted to let the committee know and anyone who I'm not sure I have one of the statute books here, but I could show you on my computer. There is the entire Wyoming Public Records Act that defines which are public records and what the different categories of them and stuff. That is at Title 16 in Chapter 4. And there's public records and public meetings, both of those entire separate acts that define all this and who's why. So when any particular agency isn't necessarily sure whether something is or is not, it's because there's all the defined terms of what is and what applies and how to and which records are in the act and how they apply.
Thank you. All right, any further public comment concerning this bill? Okay. Committee, what's your pleasure? Bill's been moved, seconded by Clausen, moved by Senator Boner. Okay. Discussion on the bill? Yes, Senator Boner.
Hey, Mr. Chairman, I think, well, we got some good feedback from state lands, making sure we have the proper achieve the proper effect based off the, their feedback. So I'll make the following amendments. So on page 2, line 14, strike parties, insert persons. Between on the same line, insert state before lands. On line 15, delete municipal and on line 16, delete elected officials and insert commissioners. Page 3, delete the S off of exchanges and also delete, page 3, line 11. Delete the S off of exchanges, delete the words a particular parcel or parcels of and insert any. And then have a conforming amendment on page 4, line 5 to make the same. Well, I'll just go through it. Delete parties and insert person. And delete municipal and delete elected officials and insert commissioners. I think that covers most of them.
So I'm
sorry.
Yeah, I also, on page 2, line 13, and I don't know whether this got deleted later, but behind opportunity, we insert, we would cross out the rest of that line. to provide the board comments to interested, and it was to provide clarity on the thing. Instead, it would say interested party, opportunity to interested party to give comment to the board. Am I correct on that, or did we change our mind on it?
I think that was correct. Yeah, that was one I missed, Mr. Chairman. So
Okay,
that's, yeah.
So we
that's-
add that to the, would you add that to? the
Yeah, that's friendly. That's friendly. And also I got a request to repeat what I said online, page 3. So basically delete a particular parcel or parcels of and insert any. So the beginning of paragraph B would be when deciding among more than one possible exchange of any state lands. So to clarify, that's what the motion was on page 3.
Mr. Chairman,
Yes, go.
may
go
may I
ahead.
confirm the insertion on page 2 and
Yes.
also request one little clarifying thing? I believe, I think it might read after the inserted text would be, would read it with what you were wanting it. After the director provides notice and opportunity to interested persons to provide the board comments. And then I think there would be a comma, and then I think it would say, including notice to leaseholders of state lands to be exchanged, owners of adjoining lands, county commissioners and state legislators from the affected county. Is that correct? That little insertion was including notice to lease, that was a couple little words to make it read clearly.
Committee, are we clear on the amendment? Ready to vote. All those in favor of the amendment, say aye.
Aye.
Opposed, say no. Okay, the amendment passes. Any further comments or changes on the bill? All right, we're ready for a roll call on, this would be 23 LSO 0200.6.
Senator French. Senator Kolb.
No.
Senator Cost. Senator Wasserberger. Representative Blackburn. Representative Clausen.
Aye.
Representative Fortner. Representative Heiner. Representative Larson. Representative Western. Representative Worf. Representative Winter. Co-Chairman Boner.
Aye.
Chairman Eklund.
Aye.
Mr. Chairman, we have 9 ayes, 5 noes.
Okay. Thank you, committee. And everybody on that. All right. I think we've. Need a break? Okay. We're gonna have a real quick break. Real quick, because it's getting late. We've got. All right. I know, we just got to lunch. Committee, take your seats. We still have another bill. And I'm going to ask the LSO if you're ready to come forward. So who wrote this thing? All right, Luke, come on up.
My apologies, Chairman Eckler.
Oh, you're fine. I'm just joking. We need something light about this time of the day.
Well, Chairman, this is 23 LSO 0203. This bill is titled State Parks Recreation Management Authority on State Lands. This bill is based on 2022 House Bill 54, but there's just a few changes here. So just walking through the bill, the initial first couple of pages address just some conforming changes to what will be bigger changes to specifically Wyoming Statute 364107. And so this relates specifically to what the Department of State Parks and Cultural Resources can do. This bill ultimately in 107 allows the Department of State Parks to lease state lands from the Board of Land Commissioners to use specifically for recreational purposes. The department is required to develop, operate, and maintain lease lands and promulgate and enforce site-specific rules. The department is required to pay for the lease lands on an annual basis per lease terms that provide the rate, and it does provide that payment to the Board of Land Commissioners. One section that was inserted here into this bill is that the Department of State Parks and Cultural Resources shall not enter into more than 5 state land leases with the Board of Land Commissioners for these purposes. This was kind of just to give it an idea of, somewhat of a pilot program to see how this would work to lease these state lands for the recreational purposes. And this section also requires reports to this committee, as well as the Joint Travel, Recreation, and Wildlife Committee on the leases that were entered into under these provisions, the department's operations and development of the leases for recreational purposes, and then also to provide recommendations for continuing or discontinuing the authority here. And so this section is specifically, or I guess I should say this subparagraph is repealed effective June 30th, 2027. So provide some time for this program to get started, and requires the reporting and the providing of the recommendations on the authority here, but then it eventually would be repealed. And so then the next subparagraph is that the department shall develop rules for a notice and hearing process that allows for public comment before entering into any leases for state lands for recreational purposes under this paragraph. And so then in addition, there is conforming amendments when it comes to that the department may lease or rent concessions. This would include on to lease state lands as previously authorized. And then also to offer for sale permits that allow for the use of state lands leased for recreational purposes as authorized in the prior section. That's on page 7. And it kind of continues forward. Starting on page 8, there is subsection H, and this is discussing the funds that is received by the Department of State Parks and Cultural Resources from the sales of permits within their special revenue fund and everything like that. But this is just basically to say that the state parks account shall be further administered. One is just is existing language in statute about how things are currently used. The new or the new paragraph 2 is that these funds that are received by the department shall be accounted for separately. And may be used to pay for leases of state lands designated for recreational purposes. They can use those funds to develop and maintain to operate the recreational use on those state lands. And then beginning for fiscal year June 30, 2024 and each year thereafter, the state treasurer should transfer any excess funding that is certified by the Department of State Parks to the permanent land fund. And so, yeah, so as I mentioned, there are several conforming amendments here that I've already kind of touched on. And section 2 on page 10 of the bill is that the Board of Land Commissioners and the Department of State Parks and Cultural Resources shall promulgate any rules necessary to implement this act. And then there's that split effective date to allow the rulemaking process to start immediately, and the rest of the bill would become effective on July 1st, 2023. Well, with that, I would stand for any questions.
Questions, committee? So I would assume that recreational uses that are happening on the land, such as hunting and other things, are unaffected by this. This is just leasing for the purpose of recreation, correct?
Chairman Eklund, yes, thank you for that. I realized I did kind of skip over this a little quickly right at the beginning. On page 2, there is a section that says what constitutes outdoor recreation areas and facilities. And specifically, their language is being inserted that this section shall not be construed to limit or otherwise prohibit the Department of State Parks from entering into lease agreements for the use of state lands. So yes, it's kind of just supposed to be an additional option for the Department of State Parks to be able to lease state lands to start using them for recreational purposes, but not really limit them what there's already being done.
All right. Representative Heiner.
Thank you, Mr. Chairman. On page 5, it says the department shall not enter into more than 5 state land leases with the Board of Land Commissioners. What's the reason behind the 5 limit?
Chairman Eklund and Representative Heiner, that was actually born out. This was originally a different bill from last session, and this was based on a recommendation from an amendment to the bill in this past session. And in discussion with state parks, I think it was kind of, well, let's limit it to 5 to just, so that it is more of a pilot program, I think is kind of the phrase that was thrown out there to just kind of get to see how this would start and how it would work, and give some limits on the department.
Then if we were to pass this, we would have to amend the bill, pass the pilot program or not, or would it just continue? I don't know how it works in subsequent years. How would it work?
Chairman Eklund, thank you for that question. Certainly. So in this specific subparagraph, which is A, so it limits the 5 state land to 5 state land leases. And there's the reporting requirements and everything, but this subparagraph, just so specifically, just this section that limits to 5 is repealed on June 30th, 2027. So that's where that kind of pilot program idea comes in.
Okay, thank you. Any other questions? Yeah, Senator Kolb.
Well, thank you, Mr. Chairman. Just a question about the additional employees. I mean, it specifically states no additional full-time employees. Is that going to also, I mean, is there a reason why it doesn't say full-time or part-time, or do they envision they're going to need part-time employees to perform these functions?
Chairman Eklund and Senator Kolb, that would be a good question to ask, whether there would be needed part-time employees. I think more for the Department of State Parks. It wasn't something I had a full discussion with them on. It just was, I think the primary thought was that there might be part-time need, but definitely no full-time employees. But that'd be the extent of my knowledge on that.
Thank you.
Any other questions? Yeah. Senator Boner.
So I'm looking at the digest from House Bill 54. It looks like there's a standing committee amendment. It looks, second reading amendment offer that was successful, that would require that the ag lessee have the right to match the lease terms for whatever proposal. Is that in this draft somewhere? Anywhere? I'm not seeing it right now.
Chairman Eklund and Co-Chairman Boner, that is not included in this bill draft. I mean, certainly if it was the committee's pleasure to add that in, but that was in discussion of this bill with OSLI and state parks. It was not, we did not include it in here.
Okay. All right. Thank you. And I think we'll have Office of State Lands come forward.
Mr. Chairman, thank you. We also have State Parks. Dave's with us from State Parks, and I think it might be beneficial if he kind of starts the discussion and then we can chime in if that's okay with you.
That sounds like a good idea. I wanted to be consistent with what we were doing, but we don't have to do that. That was getting boring. So go ahead, sir, when you're ready.
Mr. Chairman, thank you. And I'm smiling really big right now, just so you know. This is nothing new. We've been working with state lands on a lot of issues regarding recreation and a lot of other agencies throughout the state regarding recreation and outdoor recreation in the state. Our job is to help push the needle. And as Representative Heiner has said in the past, it's to push the needle the way we want to do it in Wyoming and not just do it willy-nilly and straightforward. A new Bureau of Economic Analysis report came out last week, $1.5 billion to the state's GDP, direct accounting to the state's GDP. That's 3.4%, fourth highest in the country in Wyoming. National GDP, inflation adjusted, grew 5.9% last year. Outdoor recreation grew 18.9%. So it's growing and people are coming and we have the ability to manage them or not. But at this point in time, people are here and they're coming. And that's what we're trying to do is work with OSLI and help move the needle forward. And with this bill, I see a lot of checks and balances, which I think are not a bad thing. First off, there's a pilot project. Let's try it with 5 and see if it works. The Board of Land Commissioners has to approve this. There's also a piece in there that talks about community input. And we go through in state parks, we try to run ourselves like a business. We go through what's called a site criteria process before we take on any piece of land that we manage. We look at the visitation, we look at the infrastructures that's there, we look at the infrastructure that's needed, we look at what the cost is going to be, and then we make a decision going, well, this is probably good. So it's not state parks parachuting in and saying, this is how it's going to go. And it's not state land saying, here, take this. It's people sitting down in a room and working together to figure out if this is a piece that we want to move forward. If done correctly, I think it's a win-win-win-win. I think it's a win for the state and OSLI because there's more revenue coming in. It's a win for state parks and the outdoor recreation office because we are moving the needle as we're educating, dispersing, and concentrating folks throughout the state, depending on how it goes. And we'll talk more about this. I know Deputy Crowder is going to discuss it a little bit, but the goal is to have it a win-win for the current lessee as well. For state parks perspective, if the community isn't in support of it and the current lessee isn't in support of it, we would not probably consider coming in and managing this piece of land for recreation. But we do believe that there's some specific pieces throughout the state that are frankly getting trashed to some degree where we could come in and help manage the resource, help improve the grazing, help improve some other things by getting rid of user-created trails, putting in a parking lot, potentially a toilet, those types of things as we move forward. And with that, I would stand for any questions.
Committee questions? Yeah, Representative Portner.
Thank you, Mr. Chairman. Has anybody done a study to figure out how much more fees it's going to cost the citizens of Wyoming to use these facilities than what the state has already been charging them by subbing it out?
Mr. Chairman, Representative Porter, I think it would be very dependent on the situation. That's what our site criteria would do. Would determine what that price is. But to my knowledge, there has not been a study.
Senator Bonner.
Thank you, Mr. Chairman. I appreciate you mentioning the balance and, making sure you have the leaseholder, current leaseholder on board. I'm just looking at the bill. Where is that? Where you have to get the leaseholder input or approval or where the case may be. I must be missing it somewhere.
Thank you, Mr. Chairman. Jason Crowder, Deputy Director for the Office of State Lands. We heard during the session last year that this was a major concern. And so we brought some information for you today. And the very last piece of my handout for you, page 7, is the rules and regulations for special use leasing. This is the vehicle we would use to partner with state parks to move forward in these ventures. And what I want to point you to specifically within that section of rules is section 4. It's on page 5.1, and it's called the existing lease impairment That's the title of the section. But essentially, this requires a surface lessee consent form before moving forward with the new application to lease. Essentially, what the board wants to understand is, will the new use, and we discussed this earlier, have a negative impact to the existing user on that land? And it does that by requiring the applicant to get a consent form. So in this instance, we would expect State Parks as the applicant and future lessee to provide the board with that consent form. And as Dave mentioned, they would go through a public process to try to understand what this is. Keep in mind, we're not trying to displace grazing off of these parcels, but we do want to understand what the impact would be, and that's the intent of the consent form. Of course, if the surface lessee or the existing lessee won't or can't provide a consent form, the board has another process as described in this section of rules to do its own analysis to see if there's an impairment of some kind. We're expecting this legislation to provide us with a management tool, not necessarily displacing ag, but if there's a situation and the example that we used last session, and it's still, I use the term being overly loved today, that is impairing the existing grazing lessee. If he doesn't provide a consent form, he's still being impaired by that recreational use. So we're trying to use this as a management tool to get his use and the recreational use under a management umbrella to allow them both to occur. The second part of that would be the surface lessee is due compensation for any new uses that come on board, come on top of his lease. And that's denoted on page 5.5 of the rules I provided. It's section 13. It's the surface impact payments. This is intended to reimburse or compensate that surface lessee for any monetary loss that they may experience based on the new use coming in, as well as the nuisance impact to having those new activities there. Again, a lot of this happens in the oil and gas world through ancillary oil and gas development. There's a lot of nuisance with that, which outweighs obviously the monetary loss. So we've seen these surface impact payments to the lessee ebb and flow as markets ebb and flow, but we would expect a surface impact payment to also be provided to that grazing lessee if it were approved by the board. So, Mr. Chairman, it's not in the draft bill. As you can see, it's in the Board of Land Commissioners rules and regulations.
Okay. Any other questions? Okay, thank you. Ready for other public comment?
Brett Moline, Wyoming Farm Bureau Federation. A lot of concerns with the bill. If I remember right, the bill that we were working last year did have its explicit in the bill about damages and having to get buy off by the surface leasee. And the damages can go much beyond just the surface damage with recreation damage to livestock. That's not the surface. A lot of times it's hard to quantify what it is, but the loss in rate of gain. So a lot of concerns that without having the agricultural leasee, at least to the end of his lease, having, to be able to, in the statute, not just in the rules, but in the statutes, to have essentially the first right of refusal. One of the problems I always have with the public lands being used is, are we taking away from the opportunity on private lands? There was a professor in the economics division at the university said one of the reasons we don't have as many private land recreation opportunities in the state is because the federal land is being, those uses are being so heavily subsidized. And I take that to heart, that keep putting these on public lands, on state lands, federal, that we're taking away from the opportunities that could be on private lands. And I would also like to see added to anything that is much like we've done with the game and fish, any of these lands that are, they're subject to property taxes. So if they put up infrastructure, buildings, other racetracks, whatever, that those would be subject to the property tax. Because it's the county basis, we pay no property tax to run the state. But it hurts if we don't charge a property tax on things that should be in private hands. They should be subject to property taxes. We had a bill that looked at that a few years ago and it didn't go anywhere, but I'd like to see added on this that any infrastructure would be subject, built for the recreation would be subject to property taxes to help out the schools, the counties, especially. They talking about providing notice, and we went through this with the last bill about the exchanges. At what time frame is the leasee going to be known? Is it going to be known to him that this is a potential to occur? If it's at the very beginning, when he just renews his lease, he assumes he's going to have it. Will the damage payments pay for the losses to the surface leasee, to the agricultural leasee? I'm talking with some of my members, it's kind of nebulous right now if they are paying enough, but the ability to battle and get that out there is it's not cost effective to get it. Another thing I'd like to have put in here is something about, and it can probably be covered by rules, but I'd rather have it in the statutes, that the bonding or some, and I know it's hard to get state agencies to bond, but is to recover, to make the property back to where it was. I can't think of the right word. It's lost me, but to reclamation, that's such a big word. It's hard for a redneck like me to get around it, but something in the statute that the reclamation has to be done should these things not go into, not be carried out. I look at some of the problems that we've ran into, and it's supposed to be covered by rules and regulations that, the Hot Springs State Park has been an ongoing issue. We haven't had the leases, money has not been invested back into those properties. And that has been a large problem. So as this bill stands right now, I couldn't support it. And I would urge you to not support it without some pretty substantial changes to it back. Because when I was talking about the bill to my members from the last session, well, don't worry, at the way the bill's written, the ag leasee will have first right of refusal. I don't see that in here. It could be in rules and regs, but I'd like to see it in the statute to make dang sure that it happens. With that, Mr. Chairman, I've gone on longer than I should have, trying to search for a 3-syllable word. But with that, Mr. Chairman, I would sit for any questions.
I'm sorry, questions committee. Yeah, Representative Fortner.
I see in one of these earlier bill drafts that they called for US citizen, 18 years old. I don't see anything like that in here. What would keep China from coming in here, leasing up all of our parks, everything else?
Mr. Chairman, the way I read this bill, I see nothing that would stop that unless some of the other rules the other statutes would come into effect. That is another. Actually, my members just passed policy. We don't want foreign countries owning any assets in the state of Wyoming. So that would fit right in with my members' policy.
All right. Thank you.
Thank you, Mr. Chairman.
Other public comment? Okay. I guess I would ask maybe state lands if we could find out if the first right of refusal that was brought up a couple times. Huh? It's not in there. So who has the first right of refusal? Would either of you know offhand? In the way this bill is written and in the way we would pass it?
Mr. Chairman, there's not a first right of refusal written into the bill. This is a normal lease of state lands. It's not picking and choosing who would be the lessor. It would be the Board of Land Commissioners being the lessor. We're asking those existing surface lessees if state parks took over management of the parcel for the recreation that's already occurring, if that would have a negative impact to their operations, but it's not as I would define a first right of refusal.
All right. Any other questions? Well, Jason's up here. Yeah, Representative Fortner.
Looks to me like this bill went over and above what the rest of our bills we've seen today. Most of them have 10-year limit on the lease. This one goes up to 75 years. Can you give me a reason why that is? Thank you.
Mr. Chairman, Representative Fortner, within our commercial leasing statutes, I believe it's 36.5.114, it allows leases to go up to 75 years.
Okay, thank you. Heather.
Mr. Chairman, an earlier bill, when you all were discussing whether to have the requirement for state lands, what was that requirement? Oh, for actual in use, if you recall, the committee was discussing whether to put it in the general one or the agricultural statute, and the committee determined to put it into the agricultural portion of the statute. The general portion of the statute, that I believe could be, I believe is the section from which Representative Steiner, no, yes, what was reading about the US citizen. And I believe that the testimony at that time was that that would apply to commercial leases, that general section. And so that's the whole section about the citizen and the age of majority.
Right. Are we done with public comment? Committee, what's your pleasure on this bill? All right, there is no motion. So the bill dies from lack of action. All right, we're ready for the next round here, and I believe it's our business council's gonna come. There you are. You disappeared. I panicked. I thought, well, maybe I'm missing something here. Welcome to the committee.
Thank you, Mr. Chairman, members of the committee. My name is Josh Durrell. I'm the CEO of the Wyoming Business Council. And with me today, I have Jill Tragimba, who's our agribusiness manager. I think you all know her. And it's a pleasure for us to give you a little bit of information and focus in on some of the elements of our annual report that we present to your committee, well, annually. We've got a few slides prepared, but you also should all have received the full report of this. This particular slideshow is really just a snippet. I wanted to focus in on a few elements of that. And as I'm going through this, please feel free to jump in with any questions. I'm happy to take those either during the presentation or after. So thank you. So we want to go ahead and jump to the next slide because I think we all know the year and everything. So I think we're good there. Want to just take a quick look at what we call the economic development triangle. And ultimately, this is the framework that we work upon. And what it does is it provides us a way to understand how the state entities like the Wyoming Business Council work with the local entities in order to really, what our goal is to build that local capacity. And we look at that through leading economic growth and building that resilience at a community level. And we do that with policy, with funding mechanisms or investments. And we also do that with leadership. And so we'll take a look at each of those. If we jump to the next slide, you'll see a little bit of what we think of when we think about leadership or some of the things that we do. Again, I know you all know Jill Tragimba, our agribusiness manager. And not only has she been traversing the state, looking at ways to make sure that ag is top of mind, and also to make sure that the agribusiness community has availability to all of our programs, but they've also been traveling around the United States, working on making sure that people know where we are and who we are, and how we can help them in a number of ways. And so I won't spend a lot of time there. It's except to say that we are working really hard to make sure that Wyoming is listening to the ag community and making sure that our policy and our funding mechanisms are available. If you could please jump to the next slide, I'll jump into what we'll call the investments, and this will be a little bit of fun for all of you. Well, it could also be an opportunity to take a 3-minute nap if you need it. It's been a long day for most of you. But I've got a little presentation here. It's a little video that describes our BRC programs. Now, before we get started in that, I just want to kind of take a quick step back and make sure that everybody knows about the Business Ready Communities grant and loan programs and how that works. That's really our way of putting money into communities in order to build capacity. And that's either in terms of an asset, it could be in terms of infrastructure, but it's all publicly owned. And it's all, the whole goal is to build that local capacity so that each of the communities in Wyoming could really build their own economic development engine and really have the resources and the expertise in order to help their companies grow within their communities and help attract other businesses. But ultimately, it's about building resilience in a community so that when one industry maybe takes a hit, that community doesn't completely fold, that community is able to bounce back, and that community is able to weather those storms and maybe even thrive into the future. And so if we could just take a quick look at this video. Thanks.
Can we break here for a minute and see if the committee has any questions on how this model worked? All good? Okay. Thank you.
Right.
Go ahead.
Yeah, thank you, Mr. Chairman, and thanks for paying attention to that. And I think it's a really important distinction. I think sometimes folks feel like, hey, we're giving money to businesses and that's not the right idea. And it's actually a really important distinction. And it's what makes this program a really good program for the state. Just building that resilience in. It's really important for us to take a look at that now, because our next slide, if you jump to that, please. Our next slide talks a little bit about a particular project that we've been working on since January of 2022. That is a really good example of a business committed project that we have before us. And it's a really good opportunity. We thought we would demonstrate this today because it's a pretty big ask, but it's also one of those things where it's an opportunity that we didn't feel like we could pass up. This is a company that actually started out at the University of Wyoming in the PhD plant sciences worked its way up through the incubation system there it was at the time the Wyoming Technology Business Center, now known as Impact 307, and then became a business that occupied a business that we put money into the community and built an asset, and now employs about 80 people in Laramie. And that business has since expanded. It's got a number of locations around the United States, including one in San Francisco, one in Compton, California, and some planned expansion in Virginia for one of its farms. It's possible that you saw the governor of Virginia touting one of those a few months ago, talking about that expansion. This is a really big opportunity for us because they came to us and said, look, we are looking for a way to expand our research and development operation in Wyoming, but we have some other states that are courting us. And frankly, they were looking pretty hard at those. And so we were able to come to the table and utilize the Business Ready Communities program in order to keep them here. They have their board of directors has approved that they will expand in Laramie, Wyoming, and move up to 200 employees at that location. It's also really important to understand that that is not just that location and that saving of 80 jobs and increasing it 120 jobs for a total of 200. But it's also important to think about the fact that this is a new opportunity in the world, and it's something that is looking to really expand greatly. And as I mentioned, their own expansion plans, but you have to look at the other things that grow up around a new industry. And those are things like the lighting that is used in these, the technology that they use to run the growing systems. All of those are opportunities for cluster development. And the best thing you can do in economic development is start a cluster, because what that does is it basically feeds itself. And those businesses that you've brought to town or kept in town then begin to spawn other businesses around them. And that's a really exciting opportunity for this particular project. And it really represents what we think is a great example of a business committed project, and working with the University of Wyoming, the city of Laramie, the Laramie Chamber Business Alliance, and the Wyoming Business Council to keep plenty in the state and keep them growing here, if you will, in a few different ways. Before we move on to the next slide, I'd be happy to answer any questions about this particular project.
Yeah, Senator Boner.
Yeah, appreciate that. So what's the connection to agriculture with this particular facility? I know that's general research and development, but are there any, I guess, ag-centric research and development projects you're aware of? Do they partner with the university? Just a little bit more information about what they do that benefits agriculture.
You bet. And thank you, Chairman Boner. That's a great question. And really, this is a complete, ag research and development project. And it's coming from plant sciences, and it's also looking at crops that are definitely non-competitive. Lettuce, tomatoes, and strawberries are their main crops that they're looking at. And so they're looking at ways to grow those vertically indoors. As I mentioned, they just launched their first production facility in Compton, California. And that'll be supplying grocery stores with those crops much quicker than regularly, and as well with things like less water and electricity maybe than are needed for that. The other thing that's important here is that it begins the epicenter of this type of farming in the world. I'm not sure how many of you are familiar with the Netherlands, but the Netherlands greenhouse prowess is great. That's typically where a lot of things are grown. Disproportionate amounts of produce are grown in the Netherlands. And I think people don't understand how much that greenhouse technology has evolved there. This is like a step change in that technology. And so what we're excited about is perhaps becoming kind of the epicenter for this type of farming, this vertical farming in the world. So thanks for that question.
Okay.
All
Go
right.
ahead.
Thank you, sir. We'll go ahead and jump to the next slide. The next project I wanted to bring forth is another project. It's also a business committed project with a company called Legacy Meats in Cody, Wyoming. And this one's a little bit more traditional in the sense that we've worked with a number of these organizations, and it's all about expanding their beef processing capabilities. And so I just wanted to kind of bring these two projects forth because I think it's really important, again, in the context of building a resilient community and understanding where this state money goes. It's to build an asset that's community owned. It's to build an asset that helps bring those great jobs in. And so if you look at the elements of this particular project, the jobs are all over the county median. They're all, it's quite a big expansion. And this one's pretty exciting because the private business is bringing a lot to the table as well. So just wanted to highlight that. And again, it's probably a little closer to home than others. So thank you for that. Any questions, sir, or committee on that? All right. Thank you. Thank you, Mr. Chairman. So if we jump to that next slide, I wanted to talk about the program that frankly this committee brought forth as a tool in the Wyoming Business Council toolbox to really kind of continue to encourage agriculture and continue to encourage the bigger projects maybe that could come forth in agriculture in the state. And so, you know, not only to thank you for providing that tool, but also to show you where we are in this. And this particular graphic that you see on your screen is a little bit, maybe it's a little bit hard to read, but what we wanted to let you know is that we are right now at a spot where those rules have been approved by my board of directors. Those rules are now at the governor's office, and we expect them to be signed prior to the end of the year, and then we'll be able to utilize that program. Also wanted to let you know that there are we've had two opportunities to talk with folks about these bonds and how they would be used. And the good news is it takes a little bit of time to make sure that your business is sort of bond worthy, if you will, and to make sure that all your ducks are in a row to utilize a program like this. So those businesses have been doing those activities in order to get themselves ready so that when these bonds are ready, they'll be able to potentially take advantage of them. And so that's moving along quite smoothly. So thank you for your efforts there. I think it's going to make a difference. So thank you. Next slide. Well, there you have it. I meant to take 3 or 4 hours for this presentation, but it looks like we got her done a little faster than I expected. So any questions, we're happy to stand for them and talk with you about those.
Well, as you can see, the committee is overjoyed with your brevity. Representative Blackburn.
Thank you, Mr. Chairman.
You didn't have anything to say?
We got the mouse to my right here. So.
Okay.
The vertical farming in Laramie, are we actually farming in Laramie, or are they doing it in Compton and Virginia?
Mr. Chairman and Representative Blackburn, that's a great question, and thanks for asking it. The work in Laramie is all in R&D. So the farming operations that are going on in Laramie are all for plant development, essentially, and understanding how they respond to light, how to get the best yields, all of that. And then that research is then propagated to a pilot farm in San Francisco, as well as the production farms in Compton, which just launched, and then the farms that are under construction in Virginia. Now, I don't want to dive too deep into their business model, but as we were able to look at this, the exciting part about this is that all of the research and development that will be done in Laramie will be then again propagated, not just in the United States, but worldwide. The idea is that these farms can be put anywhere If you're creating some of the highest yields in a crop in Laramie, Wyoming for things like lettuce, tomatoes and strawberries, that's pretty impressive, right? But you're able to put these farms really next to distribution centers. Well, we have some of those. We have opportunities for that with our interstate system, as well as our proximity to some major population areas. So we look at it as not just a really big win in terms of developing a cluster, but potentially down the road utilizing and having the availability of farms in Wyoming as well.
Follow up.
Thank you, Mr. Chairman. So you're saying to me that we have people excited then in Wyoming about doing vertical farming so we can get fresh strawberries in our supermarkets in Wyoming?
Mr. Chairman and Representative Blackburn, I can't speak for everybody. We haven't done any surveying on the marketing of fresh strawberries and tomatoes. I know at least one person in Laramie that would be pretty excited about that. He's sitting right here. And I'm sure there are other ones. Yeah. And I'm sure that that's a really big a really big driver, but at the same time for us, we look at those jobs and wages and the opportunity for a cluster and perhaps a tomato or strawberry or two.
So are you a farmer?
Mr. Co-Chair and Representative Blackburn, I'm going to need to confirm or confer with my counterpart here about how to answer that question.
Yeah.
I'm not going to confer, but I'm also not going to answer that question.
But we can assume that if you can grow something in Laramie, you can probably grow it anywhere. And we wouldn't have to import our winter produce from the southern hemisphere. We might be able to keep it right here in the United States is what this project is about.
Mr. Co-Chair, that's a really good point. It is absolutely, and it's a pretty darn exciting piece of technology, and it's a pretty darn exciting application in agriculture. And I think all of us around the state would be pretty excited about it. So yeah, thank you.
Good.
Yeah, and just follow off of that and I think the testimony that, Norway is really into the same sort of technology, probably for a similar reason. They have a very cold climate and it's hard to get fresh produce. And so as much as I'd love to have that sort of instantaneous build out, I understand it's probably a bit of a process as well. And I hope that, I just remember, my first duty station was on the central coast of California, and that's where the sheep herder from Converse County saw where they grew actual food for people, not just, cows and sheep. And if I think that, I guess I do see the value, the potential, even if it hasn't been fully realized yet, of, developing that sort of technology that is well suited to our climate and provide our farmers, as a farmer myself, with other opportunities to maybe do something in the winter, who knows, other than, feed out hay and work on your equipment. Yeah, I guess I see the potential. I appreciate the thought that went into it.
Thank you, sir.
Representative Clausen.
Thank you, Mr. Chairman. My question is about the revenue bonds bill, and it's probably a little bit premature, but you mentioned that they were getting ready to make themselves more marketable. Is that too onerous? Did we make it too tight? Is that a good thing? Do we take a look at ourselves and make sure we're marketable? Or are we not quite there yet with the answer because we haven't done it yet?
Mr. Chairman and Representative Clausen, I think that's a really good point, is that we are not ready to say that yet because it's just too early. But what I will say is that from my perspective, we should always be looking at process improvements. We should always be looking at how can we take this initial stab at the bonds and the legislation, and how do we continue to improve that and iterate upon them. The good news is that we're creating action right now, and we'll learn from that. Thank you.
Okay. Senator Cole.
Thank you, Mr. Chairman. Well, I was going to ask where the brochure page was with Sweetwater County, but I think I can answer that on my own question. More importantly, though, how do you go about not picking winners and losers in government when it comes to funding private entities? How do you sort that out to make sure that the government's not basically crushing another publicly owned entity and stopping them from doing business and expanding? I mean, how do you make that determination? Could you help me out with how that thought process works? Thank you.
You bet. Mr. Co-Chair and Senator Cole, that's something that we do look at. So we do look at competitive landscape, and we make sure that if there is a competitive component to that we are addressing how the particular situation is different than the competition. That's a question that comes up a lot in our board meetings and our investment committee meetings. And, you know, just to remind you of the process, we take a look at all of those projects that the communities bring forth. So the community should have some level of support for these, or it wouldn't be happening. It wouldn't be coming to us. Then we take those to an investment committee where those questions are asked, and our evaluation tool takes a look at the competitive landscape. Because you're right, the last thing that we want to do is create a situation that is detrimental to one business over another. And again, because we're investing in a community and a community asset, that gives us a little bit of comfort, but we still take a look at that at the investment committee level. Then we take a look at that at the board level. And then we ultimately, we don't fund those. The state funds those. We make a recommendation to SLIB. And then the SLIB, the 5 electeds decide whether that should be funded or not. So at each step of the way, we look at that particular issue and we make sure that there's at least visibility to it so people can make the best decision. It can be challenging though, for sure.
Well, still looking forward to the page and it has Sweetwater County in it. Thank you for answering the questions.
Thank you, sir.
You know, I think they're still waiting for a good idea from you. So just probe around and send it there. Okay, not now. Okay, yeah, Senator Wasserberger.
Mr. Chairman, my question is, how much water does it take for these farms? And how much money is going to have to be spent for heat? Obviously, in Laramie, Wyoming, you're going to have some heat for these plants. How's that all work?
Mr. Co-Chair and Senator Wasserberger, I love that question for 2 reasons. One, I get to sort of deflect some of it because I don't actually represent the company, but we dug in enough to find out the answer to it. So I'll dive in and keep it at a fairly high level, but at least enough to really answer your question, which is a good one. So when it comes to water demands, as we're looking at this research and development facility, the way that the water is utilized in a closed loop system, it is basically hooked up to a typical almost residential tap. It's not much water for that. And that's one of the benefits of this type of farming. And so that's also something that goes through the process with the city. As we look at these projects, the city weighs in and decides, do we have capacity for this type of a project? Now, this type of a project doesn't use much water. Now, energy requirements can be a little bit more because of, as you mentioned, they're working every day to reduce the amount that they need for their lighting and for their heating, but those are 2 big elements to that. And that's a really important conversation. So that's where the local economic development organization, the power companies, the city all get together and talk about how that is going to be able to be managed within that. Again, it's not an inordinate amount for either water or energy, even though it's an energy business. It's pretty exciting in a lot of ways, because if you look down the road, maybe 20 or 30 or 40 years, how that could be impacted by some of the energy that we create here, and how we might be able to utilize that for things like this. If you're able to grow, strawberries and tomatoes and whatever is next in that method in a climate like ours. Yeah, thank you.
Representative Ward.
Thank you, Mr. Chairman. If in fact they're taking this information that they've developed and after testing it here and they're taking it to another state and that's where it's being applied, how does the money generated from the program actually come back to the community that helped develop it? I guess because that's the thing I'm looking, we're developing it and it's great. It's great to be able to say we developed it here in Wyoming. But I guess that's how I'm trying to see how those funds, the dollars that are generated, come back to the community that's put the money up to begin with. I mean, can you explain that a little bit for me? Thank you.
Yeah, Mr. Co-Chair and Representative Worf, I like this discussion a lot because it is something that we need to be thinking about. The way we look at that is we look at the economic impact of a particular project. And you have to look at that a little bit holistically. Now, I know a group, I think it's 92 or so folks who are really keen on checking out revenue. That one's not my agency's jam exactly, but we want to be helpful in that. Let's just say it like that. So what I'll do is I'll talk about economic impact for a community. And so you can, and the state as well, you can think about things like property tax. You could think about those individuals who are now living in the community and the money they spend, the fact that they're a primary employer. That means that gives more opportunities for the secondary employers or those, the donut shops and the restaurants and the scene like that. You can think about that in terms of the money that's brought in from the outside, because that's a company that they don't take something and make it and then sell it within the state. It actually does go outside of the state. And so that's actually a good thing for us because it brings new dollars into the state. But more than anything, I look at those 200 jobs. And we look really, really hard at, are those 200 great jobs that people will want to move to the state or graduate from the University of Wyoming and stay in the state? And how do we take those now 200 families and make sure that they're in a thriving environment in the community? And how do they contribute to that thriving environment? If you don't mind, I'm going to tell you a quick little story about technology companies in Laramie at the turn of the century, as it were. Back in the late 90s, there were very few software development companies in Laramie, Wyoming. In fact, there were probably about 3 of them. Okay. And you could count the number of employees on, well, fingers and toes. Okay. And the challenge that we had with recruiting good software development talent, we could find it at the University of Wyoming. We could find some and provide some opportunities. But the challenge we had is if we wanted to grow and we wanted to pull in anybody from elsewhere, or we wanted to hire that student from the University of Wyoming, they would say, well, I'm looking around here, and if this job doesn't work out for me, I don't have anywhere to go. And so when we add 120 new jobs, but 200 jobs into a town like Laramie, that raises the opportunities for all of the folks in that area. And so when we look at it, not only do we look at the economic impact in a dollar sense, but we also look at it in the confidence sense and the fact that now there are 200 jobs that gives that town some more resilience. Because even though Laramie's been pretty stable and it's been pretty steady, there's really, we're trying to develop a cluster there beyond the university. Yeah, that's right. Thank you. Yeah, exactly. That's exactly right. And this is a great opportunity to do that and have those feeder programs at the University of Wyoming kicking out graduates that can go to work there. We love it.
I don't have this on. A question I would have, I'm kind of interested in production agriculture, and I'm wondering, how do you take this Jupiter program, extend it out, and have expansions in production agriculture with the many little farms and ranches we have that would like to have a supplemental deal, and they don't have the water and the resource of land and what have you. This sounds like a pretty good option for some of that. How does the Jupiter program then extend beyond Virginia or someplace else where they might be exporting some of this technology to Wyoming farms and ranches? Have they had that discussion, or is it premature?
Yeah, Mr. Co-Chair, it's probably a little bit premature, but what I will say in the principles of this company that I've worked with, and I've known their chief technology officer, chief scientist for over a decade now, just in the circles of Laramie and also in entrepreneurship. One of the keys that I think is really critical about a company is whether they're willing to pivot and try new ideas or shelve ideas when they don't work out. And I think that they're a great like example of that occurring. And so I don't know their exact plans around how do we kind of scale this so that folks in Wyoming could take advantage of it. I don't know their plans around that, but I do know that they're working hard to get the technology costs down so that it's accessible for not just maybe just large farms, but others as well. And I think that that's a question that will probably remain unanswered for a while. but it's one that we can always revisit.
Committee, any questions? Okay. Is that it?
Mr. Co-Chair, that's all from us. Thank you very much
Okay.
for listening. Thank you.
Thank you much. Oh, we've still
Yeah,
got.
just want to compliment you and the business council, Mr. Doral. I remember we had this conversation a couple years ago, talking about, okay, it's important that the business council support agriculture. There was a time there when every ag support function was completely eviscerated. And I'm glad to see you build that back up and to begin to, show some tangible progress in a very short amount of time. I think that's really commendable, and it's nice to have that done without, with just the threat of legislation, not actual legislation. So I appreciate that.
Well, Mr. Co-Chair, if I could address that, I think you were almost 100% correct when you said that, but you addressed me instead of my counterpart, Jill Trigimba. So I think that would probably be more suited, but thank you very much.
Thank you. Mr. True, I think it's 2:30. So thank you for your patience and come on up here, sir.
Mr. Chairman, thank you for the opportunity to appear before you and the co-chair and the committee. Steve True, Director of the Wyoming Livestock Board, Dr. Hallie Hazel, our state veterinarian. In the interest of the lateness of the day, I'm going to be really quick with my part because I think Dr. Hazel, you may have some questions for her. So, Mr. Chairman, if you please, I'll just begin with a quick update of a couple agency activities and a couple market basically give you a quick market report. So I want to talk about brand inspections that we've looked at the last 3-4 years. And I want to relate it a little bit to the cattle market as a whole in the nation. Our average numbers that we look at is about 1.6 million per year. The last in 2019, 20 and 21, we were up over 1.7 million of brand inspections of cattle alone, which portends to the elimination of the cow herd in the state due to drought. That number kind of continues this year. We're looking at about a 1.5 mil of inspection of cattle, which would be normally something I would say looks like a potential rebuilding, but it's not. And due to the fact that the cattle have already been gone and where there's been no heifers retained the last few years, so numbers have gone down due to the lack of availability of cattle around the state to ship. I tell you that a little bit in our revenue production, that those brand inspection numbers are going to probably remain low at least for another 2-3 years until something changes in the market that allows our producers to rebuild. So quickly, I just wanted to tell you that on the national level, it's been looked at that our beef cow slaughter is on pace to hit over 4 million head this year, which is 11% over last year's aggressive slaughter numbers. But you have to take into account that in 2022, we entered the market year with over 700,000 less cows than we did the year prior. So that should tell you what the sell-off has been around the state, kind of what our inspection numbers are looking around the nation. Our state's right in that same game, just to let you know where our inspection numbers look to go the next few years in the cattle business. That's really my quick and dirty cattle facts report to you. On that note, we are recruiting a few part-time or full-time brand inspectors around the state. Just want to share with the committee that those recruitments continue to suffer a little as time goes by. We're still seem to be being extremely lucky in getting at least one good applicant for each position, but not the 6 or 7 we used to get in the past. So I just wanted to share that with the committee. Any questions on, that's basically my brand inspection report, other than that renewal goes well. We're about 50% in this year. I don't have numbers on the folks that have taken extendeds, but on a good note, U.S. Forest Service, they bought their brand renewal for 20 years, so they plan on being around for a while. But so that's renewal and inspection numbers continue to be about the same on that rate. And our livestock law enforcement MOUs that I report to you on each time. This would have been a renewal of those contracts or those MOUs this year. All 7 counties have renewed and are still in. And our officers have 5 trainings scheduled in the short term, which I think will result in about 3 more. So, Mr. Chairman, on my part as a general agency update, that's the quick news I have. If you have any questions for me, or if you come with any, think of any as Dr. Hazel reports, then I'd be happy to answer them then.
Representative Heiner.
Thank you, Mr. Chairman. Mr. True, I appreciate you being here the extended hour. It's been a long wait for you as well for your testimony. You mentioned the reduction in inspections. What impact will that have with your revenue for your department, your budget? Will that be something that's difficult for you with the reduced inspections?
Mr. Chairman, Representative Heiner, real quick tutorial on how we treat our budget. Your committee has put in our financing section of our budget that we should maintain at least 1 year's operating fund in our brand revenue account. We manage that, attempt to run that at 2 years so that we can survive an event like this for a couple years and get that reload started. So our revenue is probably going to decrease on the brand side $200,000. That's just a ballpark shot right now. But we're in a position to withstand that due to the way we've handled that fund over the past 8 or 10 years. I would also note, Mr. Chairman and Representative Heiner, that you remember that I reported on some increased renewal fees this year. Right at this rate, our renewal seems to be going to run in that same 78% renewal rate. So our revenues may increase slightly there. But we're always careful to manage that. If people take extended opportunity of the extended revenue, that we don't spend future money now, that we earmark that money to be spent when it normally would have returned to us in that revenue. But I think we're in a pretty good shape at this point. I'm not going to ask you to be careful and don't cut a general fund contribution at this point, but I think we're all right.
Representative Winter, go ahead.
Thank you, Mr. Chairman. Director True, you mentioned the MOU program. Is that working out the way you planned? And is it going to expand at all, do you think?
Mr. Chairman, Representative Winter, 2-part question there. It's working out kind of like we had planned. I think the original conversations with this committee when we built that was we didn't know if it would stay in that form or if we would change that a little as we get down there. And I think we're getting to a point where we'll be able to review that in the next year or so. This money would expire at the end of this fiscal year. So I think sometime after the session, probably that'll be something we'll want to talk. We'll ask you to put as an interim topic that let's talk about. Is there other next steps in that process? But it's working out well. We're getting at least 1 or 2 officers in every agency hooked that want to take care of livestock. And I think it's doing a really good job of getting them out and around and meeting producers in their areas. Even if there's not a livestock thing there, but it's a good chance for the producer to get in a deputy's ear that this is what I'm hearing, this is what I'm seeing out here. And that's something we'd hope for and the sheriffs are hoping for.
Representative Wharf.
Thank you, Mr. Chairman. Director True, I was just wondering, I just had a thought. I know I'd been to some legislative meetings prior to being in the legislature. We talked about cattle theft or livestock theft. Are there any counties where we had experienced livestock theft that are not participating in the program? Or are all the counties that have had reported thefts or missing livestock participating today?
Mr. Chairman, Representative Wharf, 23 counties in the state, and we've got reports from every county. So yeah, there's, some of the biggest players are in. The ones that had the most worries are in. I will note a couple of counties around the state felt that they were in a good enough shape to chase that themselves. Campbell County for one, left the money for other counties to try and use those MOUs. So yeah, I think we're getting a good range. Here in another week or so, I think December 1st, I will meet with other agencies as we, in the new sheriff orientation. And we'll have that conversation with the new folks coming in and see what we can get done there. But I think it's helped over time, that and our program where, and we'll do it again this December at Stock Growers, where we honor a couple of deputies or other officers that have gone above and beyond for livestock. I think that's gained some attention of some folks as well.
Okay.
Mr. Chairman, if
Go
there's
ahead.
no further questions, I'd defer to Dr. Hazel for her state vet report to you.
Okay, Dr. Hazel.
Mr. Chairman, thank you. I'll try to make this as quick as I can because you may have some questions, but let's start with the easy one actually right now is high path avian influenza. I may say it's easy because it's easy compared to what else I have, but we've had 2 more backyard flocks in Wyoming, which brings us to 9 backyard flocks we've had with avian influenza. As you may have heard across the United States, it continues to spread with the fall migration of the wild waterfowl primarily. And our goal is to basically continue education along with Wyoming Game and Fish, who is doing massive surveillance as well, but to continue education of our backyard flock owners that you must keep your birds away from waterways and waterfowl, or they could catch AI and they will die very quickly. So we're trying to continue that surveillance and that education. We do have 2 premises still under quarantine, one in Fremont County and one in Converse County. The next is, you might have noticed that we had a brucellosis positive bull elk in the Bighorn areas that Game and Fish identified. And thankfully, our surrounding states have not been too alarmed by that because it is out of the DSA, but it is a bull elk, not unexpected. And when you look at Wyoming Game and Fish Department's collared elk movement, there isn't any movement of elk between Yellowstone area and the Bighorns, which is great news for us. But there is movement of those elk coming out of Montana down in through the Bighorns. And so it may have come from there. We don't exactly know, but we do know that it most likely did not come from the Yellowstone side of the DSA. So there is a positive bull elk. We will not be increasing any bovine surveillance as of yet because it was a bull elk. If we happen to find a positive cow elk, then we will do some more surveillance in our cattle in the Bighorn region. The last time this occurred was 2016-ish. And we did surveillance on about 10,000 head of cattle during that time period and never did find a positive bovine. So. The next item of note is we do have a suspect brucellosis bovine in Sublette County, which is also not unexpected. Right now, we typically find 1 animal, maybe 2 in a herd, because most of these herds are doing annual testing or they are doing their testing of all their culls and opens. So what that tells us is that our surveillance program is working. We find these occurrences when there is only 1 in the herd, and that makes it much easier and much faster. I shouldn't say easier, but much faster for the affected herd to be removed from quarantine than it did in the past, where they weren't testing every year and there were more in the herd and it was much longer to get off of quarantine. So we have 1 suspect cow right now. She is not considered a truly positive cow at this point. She'll be taking a necropsy next week, and we'll find out more results then. So we have 1 herd under quarantine for brucellosis. And this is also the time of year that we expect to have a potential positive result because it's fall and the fall herd work is ongoing right now. And I think I'll stop with that. I'm sorry. Let me throw a couple more things out there. The state vet lab is of course just swamped right now and drowning in blood samples, but they have kept up with these and are working amazing hours. And I want to put out my compliments to them and their staff. Regardless of the fact that they are short staffed, they are trying to keep up with these blood tests, and kudos to them and a huge thanks to our state vet lab staff. So I'll stop right there and take any questions.
Any questions? Wow. Representative Heiner.
Thank you, Mr. Chairman. Dr. Hazel, you mentioned numerous species for brucellosis, but what about buffalo? We we've seen in the past where some of the buffalo have been moved to different areas within the United States after a quarantine period. Have we found any indication of any positive tests with the buffalo in Yellowstone?
So Chairman Eklund, Representative Heiner, the buffalo in Yellowstone are tested by US Forest Service? No, yeah, US Fish and Wildlife. And so we often are not involved in that testing until they are moved to an area that is typically maybe a tribal area or somewhere in our state. And they have a very thorough and extensive testing program that requires multiple tests under a very lengthy quarantine period. I could probably give you a 30-minute presentation on that if you want to know more about it. Very interesting, but very, very lengthy quarantine period. So we often are not involved in those results, but we receive them when they come in and they have undergone tremendous quarantine and multiple testing. So the answer is no, we have not had a problem with any positive bison from the park. Anything else? Thank you.
Finished. Thank you very much. Appreciate the report. Okay, on my list are other agencies, and I think we're running thin on those. Yeah, we don't have anybody online, do we? Okay. All right. Okay. So I think the plan now, go ahead, Heather.
Mr. Chairman, I thought that Dean Roscoe was here
She
earlier
was.
today.
So I caught her before she went out. They're coming back tomorrow, I believe, and I'm not sure. I didn't see them on that part. but
Okay, there are agency reports tomorrow as well. And
Yeah.
so she must be planning that. Okay, thank
yeah,
you.
she was here for the presentation by the Business Council, which affects the university, I think. Yeah. Okay. Hey, Judy. What agency are you? Come on up here. Okay.
So I am Judy Blackburn and I'm a citizen here and I have some questions. Mr. Chairman, may I proceed?
Proceed.
Oh, thank you.
Yeah.
So I had some interest in the production of the fruits and vegetables in Norway. And that sort of piqued my interest. And I enjoyed the presentation that the other folks gave. But my question is, number one, does Norway have a patent on their production, on their equipment? And I would like to know how long they've been in production and how many years that it's taken them, that it took them to set up their business. And what, if any, other countries or that they're sending their produce to. And also, I'm wondering, hopefully this is tied to ag. I kind of try to tie it into what they talked about. But I think these things, if they've not been discussed, really need to be discussed. Because if they have a patent and we're working on something that needs a patent, we need to be cognizant of that. But again, perhaps they're sure of that, they've checked all of that out. So
that would be in reference to the Jupiter project that the Business Council presented to us.
Correct.
I'm guessing the committee can't answer your question as far as
I thought that.
Norway goes. we did ask a couple of questions. One was, when does it extend out to production in
Correct.
America besides? So I would save these questions and if the committee's okay with it, unless you've got answers for, I don't, and I'm guessing we don't, but tomorrow we're gonna have the university back with
Okay,
agency reports. Maybe we could ask those questions. Maybe they would know, maybe they wouldn't, but
okay,
we probably won't have the business council back.
yeah.
That would have been a question for them.
To me, it's very important before we
Go,
put the
yeah.
horse.
I'm
cart before
guessing
the
there may
horse.
be patents that the Jupiter project has. I don't know that for sure, but
Yeah,
if
seems
there are-
like it would take an awfully long time to get those patents once you get once you get the project in that position
Sure.
to get a patent. So those are my questions, and I just thank you all very much, and I will go on and say I appreciate you all.
Well, Chairman Boner has
So
something.
just so I understand the concern, are you concerned that the project in Laramie doesn't have the proper patents, or we're infringing upon what they're doing in Norway? Is that the
Right.
concern? Okay.
That's correct.
Okay, thank you.
And it would be nice to know how far out they're supplying the product to, how many, countries or whatever. That's a good word, whatever.
Yeah. Okay.
So I thank you for your time,
Okay.
and I'll look forward to visiting with them tomorrow, or else you can present the question or whatever.
We may do that if you prefer, if we can find that, or we could, we can contact the business council and see if they can answer it. Because
Okay,
there's also the Netherlands and Norway. Netherlands has the greatest amount of food production in a limited amount of space.
yeah.
I think they talked about that.
That's
Okay.
very
Anything else?
interesting.
Thank
Thank
you, Judy. Anybody else? So it's now like 4 o'clock, I believe. So, all right, pretty close to 4. We're gonna reconvene at 8:30 in the morning. Not tonight. AM. Anything from the LSO that we need to know ahead of time? Okay. Do you need any of us afterwards, or are we done? Okay, we are adjourned till 8:30 in the morning. Goodness.